Miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
You're rocking with the best.
Welcome everybody to Class 5 of the Supreme Elite Team University. Once again, another banger in store for you, because if you are part of the Supreme Elite Team University, you're
rocking with the best.
So today's class is about one thing: the difference between what a contract says and what the transaction is actually worth. Because in every consumer transaction, auto loans, mortgages, credit cards, there are 3 layers. The first layer, the contract, what you signed. Second, the accounting, what they recorded. Third, the market, what it was actually worth. Signed, recorded, worth. And the entire case is won or lost based on which one the court accepts. The core thesis of today's class is a bridge between accounting reality, market reality, and courtroom claims. So the accounting, corporate finance lens, market reality, investor lens, courtroom claims, the legal lens. Because value tells us, what is this future stream of payments actually worth today? Not what the contract says, not what the statement says, but what the market says. 3, why this matters in your cases. Every lender does the same thing. They originate a contract, then they value it, package it, and use it, such as in securitization, which means the contract you sign is not. 4, the legal problem. In court, they do this. They present the full contract balance plus interest as if nothing ever changed. But financially, the same contract has already used and possibly economically. The set you positioned. We do not argue, I don't owe. Absolutely not. Rather, we argue the claim is misstated, because if determines the contract value, then the claim is inflated beyond what they expect to collect and what they can prove from a legal standpoint.
Okay, so you're saying that the 4,666 and 20 cents were added? Because then that still doesn't even add up.
I'm tending to agree. If you take your payoff amount, you add 4,000 and 10,000, it's going to be more than your 432.
How changes everything. Example, $100 due in a year at 10% interest means is $91. That means the market does not treat $100 as $100. It treats it as $91. So now you can start to understand the concept of the concept can start to sink in. Now applying this to consumer transactions. Now scale that. This is how we're going to scale it across the board. An auto loan, $22,000. You have your finance charge of $18,000. The total payments of $40,000 plus. But the market values that stream much lower, which creates a built-in mismatch between what they claim and what it's worth.
But Counsel, I'm a little confused too now because these numbers don't add up. Counsel, I'm a little confused too now because these numbers don't add up.
Oh, yes, sir. Now, in transition to today's course teachings. So today we're going to break down, of course, professional level, apply to securitization, convert it into a new claim argument, and show how to use it in court.
Okay, so you're saying that the 4,666 and 20 cents were added? Because then that still doesn't even add up.
I'm tending to agree. If you take your payoff amount, you add 4,000 and 10,000, it's going to be more than your 432.
Convert it into a new claim argument and show how to use it in court.
Counsel, I'm a little confused too now because these numbers don't add up.
Convert it into a new claim argument and show how to use it in court.
Supreme Elite Team. New culture empire.
You're rocking with the best. You're rocking with the best. You're rocking with the best.
Welcome to this Sunday edition of The New Culture Empire. In this live stream, we unveil the new specialized services that every borrower should get. The Ledger, exposing the hidden figures. With this service, a team of both research and account specialists breaks down the numbers on your contract and match them to the actual source. In the end, the source of those fees and cost will be nowhere to be found on your contract. Need we say more? Coming to the stage, your host, the New Culture Empire. Hate watchers, don't leave. Leaving doesn't make you a winner. Winning makes you a winner.
You're rocking with the best.
Numbers on fire.
Let's go.
You're rocking with the best.
We are in the building today. We are in the building on this Sunday afternoon. And today I want to unveil something that's been 2 years in the making. I started this thing 2 years ago. And of course, it was utilized to perfection in my own case. But I didn't want to pull the strings. I said, no, let me get more. Let me see in multiple different situations. And it was utilized to perfection in a credit card case. And it was utilized to perfection so much that the suit stopped before they even wanted to make any more issues out of it. As y'all seen, as you've seen this before, I think I've showed it before. Stop dead in their tracks. It was stopped dead in their tracks. It was utilized in another situation as far as the credit reporting. Now, me, I am not a credit repair specialist or guru, but I do have a friend who actually does that, is dealt with that, and actually is a licensed Series 7 securities brokers. And if you actually want to learn how to repair your credit, if you want to learn, I'm not teaching the class. This was a professional that taught it. If you actually want to sit in and view that video, I have a specific Telegram group that is set up already where the video is already in there, and you can actually watch step by step on what you have to do to bring an FCRA claim, whatever FDCPA claim, the regulations that you need to know. Why am I doing this? Because credit report, now this is, you will be able to do this yourself. This will be able to do this yourself. And the reason why you'll be able to do yourself, because we actually went over the actual real law and the regulations. So if you don't want to continue to pay gurus for credit repair in disputes, you can watch the video and you'll be able to put it yourself. So you can save yourself $200-300. And to watch the video, it's only $75 to watch the video, and you can watch it at your leisure. You can take notes at your leisure. You'll be able to do it yourself. You know, so it is what it is on that one. But then I've noticed that one of the main things in a foreclosure and a credit card and any dispute, any consumer transaction, I've noticed one thing. Now, we already talked about the 5 lenses of the contract. The video I just played before, as you can see, Class 5 was taught in May. And months later, you can see how the teachers in Class 5 played out in a real live court case. So I had the teaching in May. And then later on, when it was needed, it was executed to perfection. This is not anything that I made up. I did not create this. I did not create this. I stumbled across it during my investigation in my own case. And what I found out later, that this is how all the professionals go and how they attack it when they are going against finance companies. This is how the SEC does it. When they're suing them, when they're, getting those judgments, when the state attorney generals were suing credit acceptance and the CFPB was suing credit acceptance, this is how they do it. Now, people are going to, this is one thing I noticed. They don't ever want to hear it live. They don't want to hear it live. They'll load in, they'll come in the beginning, they'll hear my voice, they'll leave. Now, you would think they'll leave and never come back. But as soon as the live stream is over and I look at my analytics, they're doubling back, watching my videos again. They don't want to sit in live presence. They are doubling back to catch the gems, to catch the knowledge, to catch the understanding. Now listen, just because you may not understand this concept and you may not be able to trace every dollar back to its source and use their own admissions in their own records that they filed and use their own evidence that they filed against you as evidence against them, just because many people look at that from they see that it's so powerful and they may get upset because they don't know it. So this is where who do you think you are? You must think you're smarter than everybody. I can see how that would come in. Because what better defense that you will have by your defense is using their exact evidence against them that they were trying to use against you. So every time they produce an exhibit, every time they produce a record, every time they produce a filing, every time they produce an amendment, anytime they produce those numbers is more evidence against them. Now, Loan Depot has picked up on that in this instant case. They have picked up on it. So now, just like when all the rest of them, when they pick up on it, it puts them in a precarious situation because now they have to think about it. Do we want to file this again and have the risk of it being attacked again? And now we have to explain it further when we know we have our limits, because this is, let me tell you what gets a settlement. Let me tell you what factors in when you receive a settlement. When you receive a settlement, it's not necessarily because they agree with your claims. It's not necessarily that. The settlement, especially in highly complex claims such as mine, it's not even the fact that they're going to admit, because they'll never admit any liability. It's the time and the expenses that they would have to pay the attorney to respond to the complaint. It's the time and the hours. And one of the things about these finance companies, they're always looking at, is it going to cost us more than we want to pay to defend this? And we don't have a greater than 50% chance of succeeding on this claim? Because if the answer is yes, then 9 times out of 10, they're going to settle just because it's not worth it to them fighting. That's the position that you always want to be in. It's not even worth fighting. Because now, not only do they have to defend against the claims, they have to defend against their own admissions. And since they've already asserted a position to the regulatory agencies, that's the regulatory lens, the investors, that's the investor lens, and from their financial reportings, that's the corporate finance lens, by them coming into court and saying, no, you're wrong, that opens the door up to them for further liability for pretty much misrepresenting their claims, representations, and warranties. None of that still is them saying they agree with your position, but you stockpile them with so much information. You got so much ammo and so much evidence that they have to defend, which they legitimately can't without causing more exposure to themselves. This is the point when they back out. If you are not putting them in this type of position, your administrative documents are not going to hit the mark. The days of trying to find a cheap alternative way to fight your case these days are over. I'm not going to expose the emails people sent me, but it's the same thing. I was fighting my case. I got this denied. I filed this on my own, denied. I filed this, denied. I asked for the securitization documents, denied. The game has evolved. They're always evolving and changing. We have to change with them. Do not look at it just because you don't understand it, just because you may not like the tone, just because you can't, if you can't afford it, you just can't afford it. It is what it is. But don't look at, if I only got $100 and this person has a already prepackaged template together, I'm going to take my $100 there because it's more cheaper for me. That is a losing mindset. I've seen the templates. I have copies of these templates. None of them hit the mark. Now, as I was saying earlier, this is not a system that I created. This is not a way of attacking that I created. This way is what I discovered. Come to find out, the professionals already use this. So this is how far behind that we are. We think that just because we're in these spaces and people may show the little specialized wins that the gap is closing. We as a whole are light years behind the corporations. So we can only change it one situation at a time. I'm unveiling the ledger, the hidden figures. I don't anticipate it growing into a global phenomenon. I don't expect many people to reach out because pro se litigants in these spaces, everybody has the complex that they can do it on their own. And one out of every pro se litigant draft and filings that I see, it's already incorrect from the door. It's already a twinge of sovereign citizen rhetoric. One of the biggest red flags that I see with a lot of people in their pro se drafts is they're always mentioning the Constitution. They're always trying to point out some type of fraud violation. In reality, ladies and gentlemen, they don't even understand the elements of what fraud is. Now, like I said, I've already been there and done that. I'm not going to tell you anything that I haven't already been there and done. Like I know what the rabbit hole feels like. I know what it's like. Right here, Midland. You know, a lot of people keep talking about Midland. Got to go to court defense. See the way when I responded to them. See, they settled this with me administratively. They didn't have to go to court. They didn't have to file an FDCPA. Thank you for your recent communication. We have reviewed our records and are writing to provide the following update. We have closed your account and ceased collections. You have no further obligation regarding this account. Please call customer support services if you have any additional questions. Angelique Ross, Consumer Support Services. Didn't have to file an FDCPA claim. I didn't have to go to court. That's what I'm saying. That's what I'm saying. Credit cards are so easy. And I have way more than these. That's why credit card is not my main thing. It's so easy. Especially the accounting way that's the way I use accounting. Credit, it's a letter to them. Yo, stop playing. Basically, if you try to bring a suit against me, or if you try to bring a suit or whatever, this is how I'm coming. That's pretty much, this is how I'm coming. So here, you either going to take this little $100 right here, close the account, or you sue me. I don't even want to sue you first. Hell, I'm not even going to bring up the FDCPA. Hell, I'm not even going to bring up the Fair Credit Report Act. I'm not even going to bring no sue up. But we ain't even going to go there. I ain't even going, nah. I don't want $1,000 per statute. Nah, it ain't that serious. I ain't trying to squeeze your pockets or manufacture a lawsuit. I'm not trying to file 50,000 requests. And then as soon as you don't respond within the timeline, oh, I'm going to file a lawsuit now. I know what they do online. They trying to manufacture lawsuits, file lawsuits in bad faith. Nah, I'm going to act professional. What you do, we don't need all that. I'm just telling you, this is what I agree. And even though I know I'm not even supposed to be doing it, I'll still offer you a couple dollars. Either you take it or sue me. But when you sue me, we're not going to wait for discovery. We're not going to wait for all that. Before you sue me, here, this is how I'm coming. Now you test the strength of this. And if it's not strong, then bring the suit. If it's strong, you know what to do. We have close your account and cease collections. That's it. That's it, especially with credit cards. That's it. Mid-land, that's it. As soon as they send you a letter telling me, hey, we're collecting on this account, ain't no sitting back. All right, we're gonna wait for them to sue us. Nah. Okay. All right, here. You say they owe $5,000 on the account. I give you $250. Ain't we supposed to come on now? You either take this $250 and make it go away, or you could take the $250, apply it to the account, and do whatever you need to do on the back end. But if you try to bring a suit against me, this is exactly how I'm coming. See, I don't wait for the lawsuit or let them find out when they get served. I let them know ahead of time. When the lawsuit's filed, this is how I'm coming. Matter of fact, before we even get to the discovery stage, if it gets there, this is what I'm asking for. This is what I'm asking for. This is what I have on you. You still want to go through with it? Hey, it don't matter to me. It don't matter to me. And I already got their anticipated responses. I already got my response to their response. As a matter of fact, I don't even wait for their response before I have my response. I respond to what they're going to say before they say it. The defendant may want to assert this, but however, this, they will still lose. The defendant may just want to assert that they're the assignee of the contract. However, blam, strip the dealership, take them all the way out the picture. No, we're going to stick right here with you. The defendant may want to invoke the arbitration clause. We're going to invalidate the whole arbitration clause from the door. And we're not even going to get into the arbitration clause. So many people go into that venue. The arbitration, like I said, I'm telling you, I'm not trying to, it is what it is. This is a study case. I don't arbitration. What? I don't give a damn if I put a real thumbprint under the arbitration agreement. I don't give a damn if I put a hair follicle. So you know I signed it. That arbitration clause won't even be the topic of the conversation. Because remember, the framework under the Supreme Elite Team University, as you can see in the sneak peek of Class 5, the framework under Set U is we never say that we don't owe. We don't ever say that we don't owe. We tell them, you say I owe 41,000 and some change. You sure that's what I really owe? You sure? Okay. This is what the contract says. I owe 41,000 in total payments. You sure? You sure I owe that? Okay. And then we break down, not the fact that we don't owe. I know a lot of people don't understand this concept because everybody in this space, listen, 98% of legal defense people in these spaces, 98% of legal defense people in these spaces, they've all got it from the early 2008, 2009, 2010 attorneys, when the attorneys was filing these securitization arguments. That's where it stems from. That's where you see all this FDCPA, FCRA claims. It started from the lawyers that defected from the other side to this side because they knew a lot of homeowners were being foreclosed and distressed. So this was a big way for them to make money. That's all it was. That's all it was. And now 10, 15 years later, you see every guru is a third-party debt collector specialist, a FCRA, FDCPA specialist. It's the same framework. It's not anything that I haven't seen yet, strategies that's put together from scratch like I did with Set U. I haven't, and now if I'm wrong, I haven't. But I haven't seen it yet. Haven't seen it 100% a class or webinar put together from scratch. Meaning before you held that class series, like the Set U University, that means there had to been an extensive time in research, trial, error, and it had to be somewhere where you've actually put it into practice on multiple different occasions, then refine it, retool before you finally come with the final framework. No, what you're going to see in a lot of these webinars are the same classes that has been held for years in some variation. Everybody and their mama was teaching the W-2, W-2C, W-2, where you put all your income as a withholding, file the W-2G or W-2C. Instead of the normal withholdings that were coming out your check, they put their whole balance. If we go back to when that was popular, if you look around the space, I know at least about 8 different teachers that were teaching the same thing, and the 8 teachers didn't even know each other. You get what I'm saying? Yeah. You see what I'm saying? There's no lack of originality. And I'm talking about progress. Every time 2025, you start, let's say you start in 2022, in 2020, into 2023, there should be some progress. Into 2024, it's the trajectory to still be going up. 2025, trajectory still be going up. 2026, the trajectory should be all the way to the top. No, what you see is recycled variations from what was taught 4 or 5 years ago. You don't see brand new frameworks, because the only way you'll be able to produce that is you have to be doing the real work behind the scenes. I've yet to see any social media teacher show their work and their value when a client is sitting in open court. I've yet to see it. I mean, we get it with the paperwork and the documents. We get it in responding to complaints. How effective are you preparing them from open court? Remember, it's not you in open court. It's them. I mean, what if it has to get to open court? What if it gets to trial? What if it gets to a jury trial? How do you even prepare your jury instructions? Are they prepared to know when to object, when to have legal objections, when to object, how, the foundation for the objection? Do they know how to cross-examine? Do they know how to file those in-between motions, those pretrial motions? What if the other side has an expert witness? How do you question the expert witness? How does your pro se client question the expert witness? How do you introduce documents and evidence that are actually not a part of the case? How do you get around the exception to hearsay rule? Because none of your forensic mortgage audits can ever get around that. That's why it's inadmissible. They'll never be able to get around that, because the LLC or whoever's creating that audit, they don't really have firsthand knowledge on how that system works. I mean, all they do is go on the Bloomberg terminal, get information. You get more information from your servicer than a securitization audit will give you. At least when it gets from the servicer, it's actually admissible. I've never seen any person that who got a forensic audit ever walk their client step to steps on the actions, take action, the actions you should do. You never see them around to walk them through the steps. And I'm going to stand on it. If she was with 98% of the other teachers that know the law, she would have lost their house on June 12th. She would have lost it. And remember, Class 5 of Set U was implemented in open court. Class 5 of Set U was implemented in open court. Before we get to this, we're going to play it again. We're going to play it again.
Wire to the choir. Real deals, he ain't got to say a thing.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
You're rocking with the best.
Once again, another banger in store for you, because if you are part of the Supreme Elite Team University, you're
rocking with the best.
So today's class is about one thing: the difference between what a contract says and what the transaction is actually worth. Right there. That's a concept that these pro se spaces haven't even grasped yet. The problem is, this is standard operating procedures in the corporate finance world. See, this is what they already know. This is why pro se litigants, they got to rely on faulty documents. They got to rely on errors on the other side. While you is saying your system itself is the error. Just the way you format it and structure these things is the error. We don't have to actually rely on the documents that they present, because we understand the system which created those documents that many pro se litigants are relying on. So it's not an attack on the documents per se. It's an attack on the system of how these documents are structured. So why everybody looked at me like my head was about to explode when I'm saying, no, explain the APR. Do you understand how those numbers even derive? Do you understand the real numbers behind the APR? Can you take the APR percentage and track it back to the real numbers? Everybody, we don't got to do all that. Don't just eliminate something that you don't understand. Because in every consumer transaction, auto loans, mortgages, credit cards, there are 3 layers. The first layer, the contract, what you sign. Second, the accounting, what they recorded. Third, the market, what it was actually worth. 3 fundamentally different things. I told you, your contract in a mortgage, auto, credit card, it's so hard to step away from the consumer lens and look straight for FCRA, FDCPA violation. It is so hard to not do that. What is actually tedious is attacking them from their own system. If you think these people are looking at the contract the way you see it, you have lost your mind. Signed, recorded, worth. And the entire case is won or lost based on which one the court accepts. Exactly. The court is not going to step beyond the formal labels of the contract unless you have compelling reasons why. This is where understanding their system comes in at, because you can't deny the same system that you operate in and you make millions of dollars a month from. Remember, this is beyond the theory. This is beyond the theory stage. This is what it is. This is beyond theory. Told you, already been there, done that. This is beyond theory. This is second nature to me now. It is not, you ain't got to question. Every number is not the real numbers. Every number is not the real numbers they're charging you. You think it is because it says on the contract. Absolutely not. You're being charged for things that are not even disclosed to you on the contract. But if you have a 100% consumer-like mindset, you're not going to look past anything but the contract. That's where they want you at. They want you stuck solely on the contract. How valuable is a contract to you other than evidentiary purposes if you understand the system that created the numbers on the contract? The contract automatically just turns into evidence for you. not evidence that you owe a debt. Just think about it. Everything that they're using against you now becomes evidence against them. Shit. The core thesis of today's class is a bridge between accounting reality, market reality, and courtroom claims. So the accounting, corporate finance lens, market reality, investor lens, courtroom claims, the legal lens. Because you tells us, what is this future stream of payments actually worth today? Right there. Right there. If everybody that's in set you right now, all six videos, you already understand what's going on. The Darrens of the world, the truth seekers of the world, the owls of the world, the ones, natural. Darren, when I say Darren, I forgot all the members. Dax. Everybody sees it for themselves. Signed, stamped by the professionals. Remember, my findings were ran by top-level accountants before I even had the class. It's already went through the trial runs. It went through multiple screen checks and all that, because this is the magic of the system that less than 10% of attorneys understand. They don't understand this part right here. It's a foreign language to them. Not what the contract says, not what the statement says, but what the market says. 3, why this matters in your cases. Every lender does the same thing. They originate a contract, then they it, value it, package it, and use it. Yes. Such as in securitization. Yes. And the part that was blocked out, it wasn't just that. That's why I left the securitization there. But there's multiple different levels of securitization that they use. It's multiple. That note takes on multiple different functions at every stage. This is when I say, when people talk about securitization, they're only talking about the generalized, stripped down version. You don't understand the inner functions of a securitization, because securitization, that part of the situation, is something that at least, I'm talking about the greatest minds in these spaces, the sharp minds in these spaces, high IQ, easy to break down and understand, at least 18 months of in-depth research and investigation, just in that field alone, at least 18 months, at least solely dedicated to that. That's the bare minimum. The average person, at least 3 years. That doesn't have that high level understanding. You need at least 3 years solely dedicated, at least to 4 to 5 hours a day for 36 months straight. Yes. Which means the contract you sign is not for the legal problem. In court, they do this. They present the full contract balance plus interest as if nothing ever changed. Right there. I know they don't want to hear it live, but they're always going to go back and bite my talking points. They're always going to double back and watch to see if I drop a free breadcrumb. They don't like it, but they respect it at the same time. This is why they never stay away forever. They never stay away from ever. They never hide me. They can't. It's like Pookie. It just keeps calling. The new culture just keeps calling them. They can't stay away. If they block me on the one account, they're going to set up a new account just to watch me.
You're rocking with the best.
And I'm going to say it. Accounting is not the field for the average passive pro se teacher. No. You think you only got to understand debits and credits. You got to understand all different types of discounts, different types of market assumptions, different types of deferral, even to the deferral tax receivables account, even down to what they call actual interest expense, even all the way down to the penny. You got to track the numbers to the penny. When you want to audit their balance sheet, audit their financial statements of position, you don't even understand the terms and their functions and their use. Nobody wants to understand real definitions. Everybody thinks another method for what they're used to knowing and seeing is an attack on their intelligence. No, it's not. Everybody wants to use accounting and securitization as a legal cause of defense. You're going to lose. And I'm still trying to find out, for the love of Christ, if I'm so wrong, where are the titles at? It's in August now. And you scroll through TikTok, you're rarely going to see it. I'm not talking about no administrative title washing scam. I don't count those. I'm talking about even as part of a judgment or settlement. And you use accounting and securitization as part of your evidence. Where's it at? I don't know. I saw this. This person showed me. No. If they could show you, they could show everybody else.
But financially, the same contract has already used and possibly economically. The set you positioned. We do not argue, I don't owe.
Well, new culture, you're going to lose a lot of people there because that's the primary function. That's the primary function of these space. I don't owe. What do they use securitization to prove? Oh, the lender already got paid by the investors. What they use accounting for? Oh, to prove I've already funded this loan. You deposit the note and loaned it back out to me. What is accounting and securitization used for today? To prove you don't owe the debt. So when I say, oh, we don't use it to prove that we don't owe, it's basically they feel some type of way about it because now they like, well, that's how I learned. So they think that if I'm saying something different, then they must be wrong. Well, are you wrong? Am I right? Am I right and you're wrong? If you use accounting and securitization and got your case dismissed, and I use accounting and securitization and end up settling mine, I don't know. I'm not saying you're wrong, but you can answer that question. Who's really wrong or who's really right?
Absolutely not. Rather, we argue the claim is misstated because if determines the contract value, then the claim is inflated beyond what they expect to collect and what they can prove from a legal standpoint.
But that is something that you just can't duplicate and say. You have to prove that. You can't prove that from the consumer side. But for the love of Jesus Christ, Yusuf, Yusuf, bruh, now you starting the accounting where, Yusuf, come on now, brother. It's getting crazy.
Okay, so you're saying that the 4,666 and 20 cents were added because then that still doesn't even add up.
I'm tending to agree. If you take your payoff amount, you add 4,000 and 10,000, it's going to be more than your 432.
How you changes everything. Example, $100 due in a year at 10% interest means
Oh yeah.
it's $91. That means the market does not treat $100 as $100. It treats it as $91.
That, come on, man. You ain't never, come on, man. Like this is standard operating procedures in the world I operate from. This is first time not news to a lot. That's what I'm saying. That's why I don't. That's why it's not a competition. It's an unfair. If I really want to make this a competition, it's unfair. So I don't compete with nobody. Think about this. This is standard in their world. So look how long we went without knowing. What are we really doing here? Am I doing anything spectacular? No, this is standard. This is baseline understanding of that system up there. This is standard. They've been doing it like this forever. I'm not surprising nobody in that world. The only surprise is, damn, how did you figure it out?
So now you can start to understand the concept of the concept can start to sink in. Now applying this to consumer transactions. Now scale that. This is how we're going to scale it across the board. An auto loan, $22,000. You have your finance charge of $18,000. The total payments of $40,000 plus. But the market values that stream much lower, which creates a built-in mismatch between what they claim and what it's worth.
Oh my God.
You're rocking with the best.
Why do you think they do it like that? Do you really think that it actually cost them $41,000? Do you actually, if they did it strictly off the numbers of the contract, they would not make any money. Why do you think when the account was wiped to zero, only the remaining balance was wiped to zero? Only the 19,000 was what? Hold on, let me see. I'm gonna find it. Hold on. Let me hold on, TikTok. I'm gonna find it. I'm gonna find it so you can see exactly what I'm talking about. I'm gonna find it. I'm gonna find it. Give me 1 second. Give me 1 second, TikTok. Hold on. I'm gonna find it. I'm gonna show you exactly what I'm talking about. So I've been trying to tell people this for 2 years. The finance charge is not real. Here we go. Here we go. Here we go. I got it. Here we go. Now let's do this. Let's do this. Let me share the CAC 5. Let me do it here. Open with. Bam. Got it. Now, here we go right here. This is even when they close the account, the settlement, they're proving everything I was saying. Now look at January 30th. Waived advance flash principal, $19,271.51. The total of payments was $41,000 some change, $18,536.72. Yeah, I remember the finance charge down to the T. Was the finance charge. Brought it up to $41,115.96. Why, when we waived the balance part of the settlement, the balance was only waived at the remaining principal balance? I already paid $10,077 on the account. only $2,716 was deducted from this balance, which brought it down to $19,271.51. So where's the rest of the 32 and some change that was waived? Because even in their system, they know that the finance charge is not real. Where's the extra $32,000 supposed to be wiped away? If the total contract payments was $41,115.96, why is the advance balance that was wiped away $19,271.51? Where's the extra? You want to know what it's called? It's called the one of the hold on. Y'all didn't see it? Right here. That's what it's called. The hidden figures. The hidden numbers. The hidden figures. $41,115 is what I had to pay back over a term of 7 years. When we reached the settlement and they waived the remaining balance that was owed, they didn't do it at the $32,000, which would have accounted for the principal and interest. What did they waive? The remaining balance, which $19,271. But if I made $10,077 and only $2,716 was put towards the principal, the rest of the $6,550 plus around there was where? Pew, 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 pew. Went to what? Everything that keeps their engine running. It was never part of the original contract from the jump. This is when I say TILA is a sham. The APR is a sham. The finance charge is a sham, and none of it is real. And TILA perpetrates that scam because they never required them to identify the true source of the finance charge. The only thing they say is you have to disclose it in bold numbers so they can see it. It's a sham.
You're rocking with the best.
Explain the rest of the 32,000 some change. Where did it go? The same place where it went from the beginning. All right. So it's basically saying, motherfucker, you've already paid back what you really owe on it. But that $10,077, you already really paid back what you owe. What you're really going to be paying over the next 5.5 years is our cut, the way so we can make some money. Our little fees, our advances. Remember, you're going to consume our debt. Remember, our debt, which is not really associated with your debt, it's our debt. So that extra $32,000, that's extra we're going to be receiving from you from an account that's booked at a lesser rate. But do you think they will update the account to show you that? Absolutely not. If you don't understand what I'm talking about, or you don't get in set you, or understand the hidden ledger, and allow people who understands in depth, you're going to be finding yourself off in the field somewhere wondering, how the hell did you get there? The courts are not going to look past those numbers unless there is a compelling reason to. This is where understanding that system creates compelling reasons. Look, right there, they can't even explain. Hold on, you owe. Take $41,115 and knock off $19,271.51 from that. The difference was all extra money they was trying to make off it. Nothing legally. Nothing else illegal. That's it. They're basically telling you this wasn't really never part of the legal obligation that you really owe. Since they removed it, they didn't even factor in when they was waiving the balance. So coming down to them, they're telling you this is what you legally owe. But what did they do it? They call it interest. They call it finance charge. This is where the fuck fest begins, under the finance charge and interest. This is when you're paying back hundreds and hundreds and hundreds and hundreds and hundreds of thousands. $10,077 on the principal contract. Only $2,716 was applied to the real balance. The rest is it's extra money. Given extra money that has nothing to do with your contract. But this is where the accounting comes in at. This is where the accounting classification comes in at. This is how they legally cook their books. They know from the onset that 41,115 is not really a part of the debt obligation. That 41,115, that finance charge of 18,000 and some change, had nothing to do with them lending me money and me repaying back. Remember, consumers are considered consumers of corporate debt. So if you want to leave with this vehicle now, you're going to pay back what we had to expend, to what we had to give in order to get the money. And you're going to pay back our fees, our calls, our servicing fees, and you're going to pay back our income because we got to make some money off the top. So we're going to sprinkle in $18,000 more on top of the principal. When you make your payments, you're going to cover this phantom income first, this extra income that we're getting. This is how our engine, once you reach a certain threshold, then more of your payments are going to be applied to the principal and less to the interest. But all those payments that you was making in the interest, if they applied it correctly under the account, you would have been paid off the obligation. It's not the principal balance that does people in. It is the interest that screws you left and right. And guess what? The government is not going to create any laws to change that. So when people talk about this consumer laws, they don't really understand what's going on. Notice how they limit your claims to like servicing error. There's not no claim on the books that really gets to the statutes that the law allows, that gets to the corporate finance side, that gets deep into the accounting. I mean, why wouldn't they? We paying back their obligations anyway. Consumers of corporate debt, right? There is not a law on the books that actually deals with the angle and the teachings of set you. They will never do it. As long as that goes unexplained, consumer laws are structured to appear as we got all our rights, but to leave a back door open for them. This is why a person can bring a claim under consumer laws and get awarded up to $1,000 per claim if the judge signs off on it. But investors can bring the same claims and settle for 12 or 13 million. So the borrower isn't meant to repay more than the principal only. I wish it was that true. I wish it was that cut and dry. Nope. It's not what I'm really saying. What I'm saying is the true measure of the obligation is not 100% accurate. The true measure of what they say you owe, is just numbers using from their systems, their calculations, their assumptions that they tack on with no real legal legitimate source, no legal legitimate reason. So the measure of the obligation on the contract is going to look totally different from the true measure of the obligations which they report and which they admit to and what they disclose. The angle is, hey, Your Honor, well, this is my personal, what I did. Hey, Your Honor, is it really right for me to pay back almost $20,000 more in interest and fees that really had nothing to do with the lending transaction? Should I be required to pay upwards almost $20,000 for things that has nothing to do with me? Why do I got to cover their obligations? Why are they passing all this extra debt off to me? Why shouldn't I pay what the actual economic reality of the transaction says I owe? Why do I have to stick to this contract number when this contract number is not the reality. Your Honor, that wouldn't be equitable, would it? Would you want to pay all that back and it has nothing to do with your transaction? This is why all that money you're paying is not even reducing your principal balance. You're not receiving no benefit from that. They're not giving me a kickback from the proceeds they generated. Why I got to cover their end on top of my debt? That don't sound right, do it, Your Honor? That sounds a little crazy. Your Honor, this is where the money's really going. TILA never required them to disclose that. I had to go over the hills and through the mountains to sit there and show you exactly what's going on. I had to put 16 months into this. TILA never required them to just come straight up with it. Congress doesn't require it. I mean, I get it. The government got their biggest hands in this, so the government's not going to make a law that's going to be a conflict of interest to them. I mean, I understand the government is engaging in shadow banking through their GSEs, using their GSEs as banks because they legally can't do it. So they're using their GSEs. I know the government is pledging our receivables for their own financing, using our receivables so they can issue more treasury securities. I understand the game gets bigger than me. I understand if you fly too close to the sun, you'll get burnt. So I'm going to talk about just me. Why do I got to do it? They got 30,000 other people in the pool. If they cool with it, this lawsuit ain't even about them. It's about what they doing to me. If they want to pay it, cool. But I don't feel comfortable. Can you make them answer to this? Yes. Yeah, I think they should. February 9th, you need to respond to this. And February 16th, you need to respond to this. Mr. Thomas spoke to my client. I showed them your proposal, and I showed them a proposal. I spoke to them about your proposal, and they allow me to present the following response. We're going to close the account, and of course you will. Thank you. That's the right move. Yep. Arbitration clause. Yep. Yeah, go ahead and throw that to the side. You ain't got to worry about that. No motion to compare arbitration here. Nope. You can throw that over there. No. That won't survive. You can't arbitrate. That should be a whole nother. I should have a whole nother class on that. The arbitration clause. I should have a whole nother class on that. I ain't going to. I should have a whole nother. Yo, they are shamming people with the arbitration clause. They are shamming people with the arbitration clause. They are shamming them. That's another sham. The arbitration clause is inserted in these retail installment contracts for no other purpose than to shield these finance companies from judicial scrutiny. Because if you look at the arbitration clause, it's a one-sided written contract. Oh, it was in mine. Any claims you agree to go here? I said, you can chop my whole hand off, and I'll give you the first one, the middle one, for that arbitration clause. You tripping. Basically, I told the judge, Your Honor, by enforcing this arbitration clause, and I mentioned it before they even had anything to say about it, I anticipated they was going to do that. I anticipated. I read over 80 cases involved with them. And when the people were represented by the lawyer, I was like, maybe I'm going to find one who had none of them ever brought claims like this ever. None of them. Every claims that the lawyers brought on behalf of their clients against credit acceptance was FCRA and consumer appliance claims. That was it. None of them attacked this. This is why I was fearful, because I'm like, they haven't seen this type of argument since credit acceptance inception in 1980. Because I had other people, and all we did for 4 months straight was live in the docket sheets, live to see if anyone brought a claim like this similar to mine. And After 4 months, we concluded this will be the first. So I'm either going to be flying too close to the sun or they're going to settle. There's no way we're having a trial on this. It's too sensitive to have a trial. Nah, absolutely not. And I fear that where you're attacking the system, you're not just attacking them, you're attacking the system. So this is bigger than you. You could disrupt their whole system if the judge awards you a judgment. You can disrupt their whole system. Millions of Americans are depending on this same system you're trying to disrupt. Your claims may get denied just because there's a bigger picture, bigger game being played. So I was actually fearful of that. I said, this may be too much. Facts.
Counsel, I'm a little confused too now because these numbers.
Yeah.
Counsel, I'm
A built-in mismatch between what they claim and what it's worth.
But counsel, I'm a little confused too now because these numbers don't add up. Counsel, I'm a little confused too now because these numbers don't add up.
Oh, yes, sir. Now, in transition to today's course teachings. So today we're going to break down, of course, professional level, applied to securitization, convert it into a new claim argument, and show how to use it in court.
Okay, so you're saying that the 4,666 and 20 cents were added? Because then that still doesn't even add up.
I'm tending to agree. If you take your payoff amount, you had 4,000 and 10,000, it's going to be more than your 432.
Convert it into a new claim argument and show how to use it in court.
Counsel, I'm a little confused too now because these numbers don't add up.
Convert it into a new claim argument and show how to use it in court.
Supreme Elite Team.
Yeah. Class 5, that was in May. That was in May. That wasn't after the June 12th trial. That was in May. The number one thing, and we're about to get into the unveiling of the hidden figures, aka the ledger. The ledger. Now, it's part of a division of the Supreme Elite Team University, got the Accrual Accounting Collection Agency. The Hidden Figures Report, Part 1, Where the Money Hides, How Undocumented Charges Survive Inside a Claim Balance and Why They Fail When Tested. So, the framework is accurate balances, accurate amounts due. It has to be proven with reasonable certainty. And of course, it has to be accurate. Now, I haven't found case law that dealt with the nuances and if they were off by a penny. So I'm going to assume that accurate balance due includes a balance down to the penny until I find case law that says otherwise. Every collection case rests on a number, a payoff figure, a reinstatement quote, a deficiency balance, an affidavit of amounts due. Now, I know inadmissible hearsay, the evidence are not sufficient enough to survive a challenge to Rule 12b-6. But I think that the framework that I've orchestrated, it actually makes the admissible hearsay. It makes the you can't rely on these documents. It actually provides an extra layer of strength when attacking these documents. Because remember, we're not breaking down and trying to find errors that's on the document or the affidavit itself. That's not the initial. The numbers that they are producing is the evidence. So it's not even saying, hey, this person just asserted that they have knowledge. Well, how do we know? It gets beyond the, you haven't proven that you owe. You haven't proven that you know. You haven't proven this. It gets to, these are your numbers. These are the hidden figures that's hidden inside those numbers. These are the unreconciled amounts. So your own system, your own admissions, your own numbers, your own unexplained balance, your unexplained balance, your own unexplained 1,700 that you slid up in there. That all this evidence right here automatically invalidates your affidavit. Remember, using the system to invalidate their own evidence. So I don't got to get to, well, was you there? What time and place was you there? Was you there at 2 o'clock? What did you have for lunch that day? No. Your own system invalidates the affidavit. I think that's stronger. It is a summary of underlying records assembled by software, adopted by a witness who did not create it, and offered into a court as though it was so proven. This report explains what we look for inside that number, why the charges we find are frequently unsupported, and what happens to a case when the supporting records are tested rather than assumed. We do not argue that the debt is void, that the note was destroyed, or that a securitization erased anyone's obligations. Those arguments lose, and they lose the rest of the case with them. We argue something narrower and a far harder to answer. The specific dollars inside a claim balance cannot be traced to anything the contract authorizes. Remember, the source. We track every penny. And yes, they are good at what they do. Remember when I said they will take $3,000 in extra fees, and they will spread that $3,000 across multiple accounts and advances and insurance. So they'll add $70 to your insurance balance. They add $100 over here. They'll add this there. So with the framework, when we find out, real live, when we found out all this extra unexplained funds, and it came up to like $3,900, I said, hold on. This $3,000, they've already asserted that in attorney's fees over here, the exact same $3,000. So they took, they double up the $3,966 and spread it inside of some miscellaneous advances, and they spread it across multiple entries across one. We went and found the extra $3,000 they were trying to stick in there across 105 different entries. We took all the unexplained amounts, added it up. I said, hold on. That's the same exact number that they got as attorney fees. Or they trying to double dip. Yeah. Remember, 105 entries, you did this. You made this. You filed this. I think that's a stronger framework. A hidden figure is any dollar, a claim balance that cannot be traced to one of 5 sources. The principal actually advanced to or for the borrower, interest at the contract rate computed on unpaid principal, escrow actually dispersed to the taxing authority or insured, a charge the instrument expressly authorized in the amount actually incurred, a late charge computed by the formula the contract itself states. That is the entire test. The value is that it is falsifiable. The other side can defeat it at any time by producing the trace. In our experience, they frequently cannot, because the trace runs into a third party's records that no one on their side of the table can authenticate. AKA, the trace runs right back to the corporate finance side. Remember, I've seen a real servicing agreement. I receive it, I have it in my file. I look at it almost every other day. You would be amazed at all their obligations that they're passing off to us. Like, they have no respect for consumers and borrowers. We get the ass end of the stick. The 4 dimensions, sources. We do not build the case from argument. We build it from what the other side has already committed to in writing, then show that their own records contradict it. I think that is a powerful, because you want to know why? Because it does away with theories. It does away with my signature created the money. Because that is a theory, because you don't have anything to support that. And what you use to support it is nothing more than passed down theories from others. That our signature created the money started with the earlier Patriot movement, the redemption movement, that has significant ties to white supremacy. That's not even anything anybody that says it today actually researched or found. The sources are very limited. It's always going to be the modern money mechanic as the number one source, when the modern money mechanics was talking about a system in which the banks have evolved from since then. But I was on a panel and everybody kept relying on the modern money mechanics. And as soon as I said the modern money mechanics is outdated as it goes to banks, how they lend, how they fund, how they operate today. No, it's not. It says it right here. Do you realize what year they're talking about right there? If you were in the mortgage reality class, you would know exactly what I'm talking about. Not because I'm saying it, it's because everybody that was in the mortgage reality class saw it for themselves. And we went through multiple regulatory sources confirming how it goes down today. And none of it stated what the modern money mechanic says. As a matter of fact, we actually use the Federal Reserve Bank today as evidence that it doesn't go down like that. And then we went to over how it actually went down from the people who provides the funding. So anytime I hear someone say your note created, your signature created the credit, that's more time and energy wasted on getting to the real meat and potatoes of the issue. It's just wasting time. Source, the instrument, what it established, the only charges that may lawfully be assessed, why it binds them. They drafted it. A charge outside it has no authority, however customary. Remember, court, contract law, negotiable instruments, pretty much a contract, a promissory note. You get it? It's pretty much a contract. A negotiable instrument is pretty much a contract. And they use, remember, it's one of the things I've came up with. They use trust law to siphon our property from us. They use corporate financing and accounting to hide the real reality and what's going on within the transaction from us. And they use contract law to stick us with the debt. The time you close and from the time it hits the trust and everything, all the different adjustments, all the different reconciliations, all the quarterly, the yearly adjustments and all they doing, all the amounts that they're taking off your balance and putting it here and putting it here. So when you make your monthly payments, a part of your payments is going to this account. Part of your payments is going to this account. Part of your payments is going to this. Part of your payments going to that. The rest is going to the principal. but that's under the guise of interest. Why do you think your interest payments are the most is being applied to? You really think it's interest in the traditional sense? They can get away with calling it. This is how they double dick, and I catch their hands in the cookie jar every time. Every corporation does it. I catch them all. Their hands in the cookie jar. And then, thank God to the homie T-Dot in this connections, the SEC attorney pulled the curtain back more for me so I could see even more on the inside. And that helped taking what I saw and implemented it and set you and implemented it in you know, the things that I do. It adds more strength to it because that is what they can't deny. See, I don't deny the fact that I got professional assistance along the way, but I did a lot of the legwork. The only thing the professionals really did was just confirm it and be like, here's another bam for you. But mainly the professionals was used to confirm my theories, confirm my assumptions. Public filings, their own stated accounting policy for advances and recoveries. Why it binds them, signed and certified. A policy stated to investors is difficult to disclaim to a borrower. Program guides, obligations they accept as a condition of participation. Why it binds them, contractual undertakings to the program, testable against what the file shows. Their ledger, what it established, what was actually posted, when, and in what amount. Why it binds them, they produced it. It's the strongest source precisely because it's theirs. Like the people don't, like there are so many more different forms and files that they have to file to prove that they legally acquired or reacquired possession of the note. But what are they going to do? They're going to file a copy of the original note or with the endorsement and file it with the complaint. I don't even have to see it to know what's going to happen. A person sent me their mortgage files yesterday, and I was like, I as soon as I looked at it, I just skimmed through it. I said, yep, here it goes right here. I can already see it right here. It's the same. They're going to do the same thing every time. It's all the same. Remember, I'm speaking on it from a system. They all operate in that system. All the banks, all the non-bank corporations, they all operate within that system. It's the system that we're attacking, not a specific lender. The lender is a representation of that system. We attack that, chop the head off, the body falls. We attack them from the system. The lender falls to the wayside. And then I inserted the principles of applied science from my days when I was in college. Applied science is probably one of the best things that I ever, one of the biggest gems I learned from my time in college. And I went to ITT Tech for those who want to know. The 3 layers, every charge must survive. A charge is not valid because it appears on a statement. It has to clear 3 independent tests, and it dies if it fails any of them. And this is the problem. When people send me their stuff, I don't think they understand. You know, you're actually sending me evidence to use against them. The mere fact that they provide you those statements and those payoff quotes and all that stuff from your request when you send to the servicer, it's evidence against them. Stop trying to attack. You know what? I ain't gonna tell you what to do. We don't attack the documents they send us. We use it as evidence against them. When have you ever seen a person take everything the other side filed and convert that into their own exhibits against them? Taken from the plaintiff's own filing, Exhibit A. Taken from the plaintiff's own exhibit. This is our Exhibit B. Taken from the plaintiff's own asserted balance. This is our Exhibit C. We take everything they use against us and flip it and use it against them. I know it's not a normal concept you hear, but it is what it is.
The layer, the question, and how it fails. The layer, the authority. Does the contract permit this charge at all? And here's the thing about the contract. They're going to use a vague term when it gets to the charges that may apply. It's a vague term. The reason why they're using a vague term, because they don't want to tell you the true source and why they're charging those fees, especially late fees, things like that, because they're charging you that because that charge is tied back to an agreement that what they say you're not privy to, what they say you have no interest in, but in reality, you're actually the guarantor of that agreement economically, because you're the source of the payments on that agreement. Oh yeah, if we got to do this, we're going to get it back from them. That's the only reason why the investors in them even agree to it. Hey, don't worry, y'all. We gonna get it back from them. Are they explicitly telling you that? And then it's not going to be anywhere in your notes or your deed of trust or your contracts. It's not going to be there. They're going to leave it out. That's the corporate finance side. That's directly tied to your consumer side. That's the corporate finance side that they're going to leave out of these consumer transactions. So it's beyond the hidden figures. We had to find the missing pieces and explain, why are these pieces right here that are directly tied to this obligation, why are these pieces left out? And the contract is right there. But why is it left out? Because the contract is the shield to those missing pieces. They shield you right there with the contract. Does the contract permit this charge at all? How it fails. The instrument names specific categories, charges that fit none of them. What they're charging you, it's never mentioned in any part of the note. None of it. And so what happens when they produce a judgment balance or a claim that you owe this amount, and then they attach the note? That is direct evidence that they have already misstated inaccurate balance.
You're rocking with the best.
Back in the day, when I was, because I'm always a student of the game, but when I was kind of like in my early rookie stages, I was excited to hear things that I didn't know before, regardless of how much I knew. I'd be like, yo, okay, I know this. And then I hear a brother drop some jewels on me. I didn't just automatically feel some type of way towards the brother. I actually wanted to get closer to him. Like, oh shit. Because I know if I learn from a person that's more experienced than me, that's going to strengthen me up in the future. And this space is very weird. It's like everybody got to protect some pride and ego, got to feel like, it's like they get upset if they hear something that they didn't know was true, just because they thought what they've done and their success in their way, that was, go do your way. It's okay. But in this space, it's very weird. It's like people don't want to hear nothing that's above. They got to stay there on their level or beneath. Trace. Does the lender show what was actually incurred in this amount? The aggregate does not equal the sum of its parts. Amounts are duplicated, reversed, and re-added or marked up. And here's the biggest effery that they do. You can't even ask them to produce the right stuff. I'm sorry, I know we got to get out the mindset of trying to get them to validate our points or ask them for the things that we need to use against them. They're not going to send you any of this stuff that I'm talking about, the authority to chase the ledger. They're not going to send you the 100% real deal. They're not. They're going to send you a copy of the contract, your activity, customer activity report. That's it. They're not going to. So you think, okay, I hear what he's saying, so I'm about to just write him and ask for it. They're not. Hey, can you provide me with all hidden fees and anything that's not related to? You think they're going to send it to you? No, they're not. They're going to send you the same thing. I'm talking about a framework that's already been discovered.
I already know what to look for. I already know their other agreements. I already know what's in it. I've already broke down the numbers. You're not going to be able to break down the numbers just by trying to break down the numbers from the contract. I'm talking about another system that has to be broken down. Proof. Can a witness with personal knowledge get it into evidence? How it fails. The underlying invoices belong to a third party. The witness reads a screen and cannot say how the entries were made. Most claim balances we examine fail 2 of the 3. This is the finding that changes a case because it converts an accounting dispute into an evidentiary one. So you notice how we did that? We took it away from just an accounting dispute. Remember, you can't use accounting as a defense. And we took the real dispute, which is an accounting dispute, but we masked it as an evidentiary dispute. Just like I take accounting and securitization and really argue that, but I mask it under consumer laws and violations. I use the vehicle. So we put a mask on. Yeah, the courts think it's an evidentiary. The lawyers look at it as an evidentiary, but we know this is a real accounting dispute. And the accounting dispute ties back to the corporate finance lens. This is the lens that they don't want to talk about, but we're going to keep parking it under that evidentiary. Where the hidden figures lies. The categories below recur across mortgage, auto, and revolving accounts. The specific test we apply to each, the document that exposes it, and the arithmetic that proves it, it's reserved for engaged clients. Aggregate advance buckets, a single line summarizing dozens of underlying entries presented without the entries test. The test is, this is blank. Like I said, this is unveiling for new clients. Duplicate fees, the same cost charge inside a balance, and again, is an itemized line detected by. So the blocked out ones, this is how we found it in these areas that's blocked out. Affiliated markups on property preservation, expected and valuations, where the amount billed exceeds the amount paid by the vendor, exposed by. Advances exceeding the disbursements they funded, an advance posted in one amount against a payment made by another, found by blink. And yes, I will admit, I wouldn't call it a cheat sheet. Let's just say what I look for in the source that I know, they don't really make it public. And I wouldn't have never got this if my friend wasn't friends with the ex-SEC attorney. I wouldn't have got it. It's like I wouldn't have got this sales and servicing agreement. It's like I wouldn't have got the SEC attorney's discovery request from when he worked for them, because he's finance company. So it's part of my extension of when my clients, part of their benefit is I use the same things that he has, that powerful information I got, and I use it with them. Like I don't just hold it and just like hold it all for myself. I actually use it in cases that I'm in. One of the most recent cases I use is the Loan Depot. Late charge pyramiding. Repeat assessments against a single unpaid installment where the contract permits one. This one is often computable from the ledger alone. Interest accruing on charges the instrument does not authorize interest on. Isolated through. And I bluff them all the time. Although I've seen one sales and servicing agreement, just a private agreement between them, the government, and the investors. I know that it's standard. It may be different companies, but the charges that so in that document I'm talking about, they're taking charges that they agreed on The lender owes, but the lender passes on to us. So it's never directly on the contract itself because it's in a private hidden agreement that they have. So what I do is, instead of alerting the courts that I actually have it, because I'm really not supposed to have it, they could strike it. I'm not really supposed to have it. So what I do is I say, this is customary. So I just point out the charges and name the charges and name all the charges and then bluff it. This is what you're charging under the contract. They all fall for it. They fall for it. But I don't attach the actual agreement. No, because she's not supposed to have that. Everybody just wants to attach things. Here's the bombshell, attach it, because they're so focused on, oh, this is going to say I don't owe anymore. Oh, this is going to get. We have to get out of the debt elimination mindset in order to be effective in this manner. We have to. The debt is going to wipe away on its own. Remember, 16 months of investigation. 16 months of investigation. The settlement happened in a few days. The end results was the quickest, fastest process. Isn't that what everybody wants all day, every day? Title to their assets without having to pay for it. That is not the end goal that you should be worried about, because that's going to happen on its own as a byproduct of understanding their system. When you focus so squarely on that, you're going to miss the hidden pieces. It's bad enough the hidden figures and the pieces been hiding right in plain sight for decades because we got caught up on an auxiliary arguments. We got caught up on the average everyday social media arguments. We got caught up on regurgitating everything that we hear, and as long as enough people say it, it must be true. We got caught up on that. We've been misled mainly by the same people who said they're here to quote unquote free us. Does any of these gurus have evidence that they executed the same thing that they teach in their classes and they was able to achieve for themselves what they're now helping achieve for you? I always find it very interesting why so many gurus online has all the answers, all the antidote for others, but they can never seem to save themselves. They can never seem to win at least one case in court. They can never seem to say, hey, this is what I did. I got my asset free and clear, balance wiped away. I led the way for y'all. The framework is applicable across multiple transactions. I'm going to teach you the understanding of the framework on the system. So your end results, you can already understand what you have to do to achieve them. No, the reason why y'all staying away from me is because you have been conditioned to purchase the templates, purchase the negotiable instruments, purchase the quick, fast microwave remedies. But if you actually knew what it took to survive in this space, to survive in the lane that I'm in, and if this whole space only operated from this lane, less than 2% would be in these spaces anyway, if you knew from the door what it took. Another one, amounts already capitalized in a prior modification and then charged the second time requires blank. You see all these things? These are the hidden figures.
Third-party recoveries never credit. Insurance proceeds, guarantee or claims payments, refunds, restricted funds held but not applied, located by. Why this breaks the evidentiary record, not merely the arithmetic. This is the part most people miss, and this is where the leverage actually sits. When a payoff letter states a single figure for accumulated advances, that figure is a summary of records the claimant did not create. To put it before the court, they need 3 separate things, and each is an independent point of failure. The underlining vendor invoices, which are third-party business records, not theirs. Adopted foundation, testimony, they rely on those third-party records in the ordinary course and have a process for verifying accuracy. Many witnesses cannot supply this on the stand. Arithmetic that reconciles the total they're asking the court to enter. A single unexplained figure therefore produces a compound failure. Remember, I said it. I'm an accounting guy. I'm a numbers guy. If one judgment figure's off, everything is off. They try to come back with an updated judgment figures. That's still going to be off because you can never reconcile and explain the first figure. So you're adding more numbers on top of the judgment. Now, the difference between the first figures and then the second updated version and those figures, that's where the numbers are still going to be off. Loan Depot had to learn that the hard way in court June 12th. That you can't go, there's every new figure, you're going to keep updating. And the difference between the third figure now and the second figure, those numbers, it's going to compound. In order for you to go back and get the numbers right, you would have to go back and explain and mention the things that you don't want to talk about in open court, because if you did, then you would prove that these balances have to be reconciled, which creates an even lower balance than your initial certain amount. Now you got to go back and go to the lower number. Look how that looks in court. You asserted this higher balance. Now you're going back and reconciling the account, doing things supposed to do. Now it's a significantly lower. You get what I'm saying? See how much confusion that caused? That looks crazy. And to a law firm in court, that's an embarrassment. Hold on, Your Honor. These numbers were high. They owe way, way, way less now. Now you got to explain why they owe way less. It's all going back to my central point. This causes confusion. And I love confusion in court. I love the awkward silence in court. Those little 30 to 45 second intervals of just silence. I love that sound. A single unexplained figure therefore produces a compound failure. The number is wrong. The proof of the number belongs to somebody else. This is why they can't explain it. When have you ever seen them file updated judgment figures and the amount due at the top of the page is blacked out? Remember, I told you, I made a call. I said, man, I've seen this document before. It was my client's, this is the document Loan Depot filed in court. It was the judgment figures. It was the updated one from June 4th. And came back to me. He said, you talking about this sheet? It was the same exact font, the same exact document. The only thing changed was the borrower's name and the servicer. And this document, it was Lakeview. The one we got, it says, who? Loan Depot. So it's not your original document. I know whose document it is. Because my Fannie Mae friend, he confirmed. He said, yeah, that's the document we use. We put that together. The whole GSEs, they use that document for all services. I said, I knew there was a reason why I liked you. He started laughing. Yeah. We all use that. We send that to the services.
for court. Yeah, we send that to him. I said, oh, I knew I liked you. See what I'm saying? But nah, the focus on, hey, you should tone it down a little bit. I mean, you got good information, but no, there's no but on the good information. Don't try to dilute it. Don't dilute it. We know the real problem isn't the tone. That's not the real problem. The real problem isn't the tone. We're going to explore what the real problem is after we get through this report. Y'all going to see the real. You're going to hear what the real problem is. It's the real problem that many people who say they have a problem with me don't want to admit. We know what the real problem is. We know what the real problem is. And it's the same problem that pro se and non-teachers have with me as well. Oh, we're going to explore what the real problem is. All right. Business records treatment is available only where the method and circumstances of preparation do not indicate a lack of trustworthiness. And the unreconciled total is precisely that indication. If you have a mortgage, if you have a auto, if you have anything where there's certain balance against you, I guarantee you, send me an email, send me a DM. I guarantee you. Now I don't work for free now, but I'm a proof. I got a point to prove. I guarantee you, I'm going to find the hidden figures, and when you get your report back, it's going to track it right back to its original source, which they can't deny. Now you got an incorrect balance. Now they're trying to assert an incorrect balance to you. That gives you leverage in the court. Hey, Ronald, they're trying to assert an incorrect balance. And we're going to provide you the case law to support your position now. And steps on how you assert this. You don't just throw it out or not. We're going to a strategic way on how to slide it right in there on them. If you are not a part of the Supreme Elite Team University, you are missing out on one of the groundbreaking universities that's out and on demand. You don't believe me? The most recent member of the Supreme Elite Team University is Brother Truth Seeker, and I think he's on TikTok.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume. What stories in the fine lines.
What this does to judgment figures. A summary offer to prove an amount due must tie to the records it summarizes. Remember, must tie to the record summarize. Right there. You see that right there? Right there. That's where it starts to break from the contract. When it does not, the summary is not competent proof of the amount. What happens when they cannot prove the original amounts or the original amounts undue? It leaves them stuck in a position. Now, for all my credit consumer people, my FCRA, FDCPA, this report walks you a consumer claim, a consumer violation. Amounts due, inaccurate credit reporting inaccurate amounts due, reporting that I owe now and I don't owe this, misrepresenting, falsifying information. The mere fact that you sent me this statement and I got proof, black and white, and with your admissions that this is not the reality. See all you FTC, see all you look. This is I'm gift wrapping you what do you call it? Your FTCB, FCRA claims. See how it transcends just court. And again, see how accounting transcends all these venues. I've gotten so many things just with experience and all them inside of 10 days. I don't know. As a bonus, I may throw. See, that's the part. I really don't like to commit to I'm giving you a document that I use because I know it's going to start circulating. And I know many teachers, one of them going to get their hands on it. One of them going to get their hands on it and they're going to repackage and sell it. But the document that I sent to Experian and Equifax, inside of 10 days, bam, bam, bam. All off the accounting. So this right here, it transcends. It deals with the consumer reporting and your credit side. It deals with all of it. And I don't even sell consumer credit rebate. I could. Do you not think if I wanted to just focus on FDCPA and FCRA complaints, suing them, knowing that their own response to me is going to be evidence against them, knowing the accounting, knowing the numbers don't add up, knowing that I can tie so many consumer violations to misrepresentation, false, everything, pretty much lying about their balance due, inaccurate reporting, inaccurate balance due that you're reporting. Don't you not think, you know what? I don't know. I just may. I don't know. You never know. That is ordinary enough to defeat a motion for judgment on the amount claimed, even where liability itself is not seriously disputed. And look at the gem. We're not even disputing that. We're not even disputing that she don't owe. Yeah, we owe under this note. We just don't owe the amounts that we don't owe the amounts that they say we owe these judgment figures. We're decomposing their whole balance due from origination. That's what we're doing. We're decomposing. So eventually it's going to show that from the beginning. Oh, you told on mama she got my jersey on? You told on it? Thank you, Fat, for telling. Thank you. Now take it off. She told on it. Thank you, Fat, for snitching. It goes back to the inception. Remember, it gets to a point where we're not saying we don't owe. We're saying is from the beginning, these amounts were inaccurate. Here's why. From the beginning, this contract with credit acceptance, this contract was dead the day I signed it. You didn't have the legal right to collect the same day I signed the contract. Your Honor, I still paid them for 16 months. See how good that, see how when you give equity, you get equity in the end? See how it was a benefit for me to pay on the contract? And it is frequently enough to change what the claimant is willing to accept. That goes into restructuring the balance due. You know, if I file all these lawsuits against you, consumer laws, you know you'd be stuck. So the remaining balance is $300,000. Okay, we'll offer you $100,000. I would tell my client to take that with a structured principal interest payments that's enough for them to stand. Let's say they came, you owe $400,000, but they come back to $100,000. Would y'all look at that as a no? Just 100% no? Dude, I think that's a win. And you got the leverage in how it's being structured. If they say, hey, 100,000 from, that's fucking almost 400,000 you don't have to pay. You're pretty much just paying the principal back. I don't know. Put it in the comments. I think that would be something I would tell my clients to explore. We'll do our A, man. That don't look bad. That don't look bad at all. 100,000 principal only? Hey, man. What, $1,200 a month? I don't know. That don't sound too bad from 400,000, 500,000, 600,000. That don't sound bad at all. And it's an asset, and the value is going to increase on it as the years the median value. What if the value increases? You can borrow against the value of your home. Now you got the biggest asset for financing. Hell, you can sell it. Let's say you want to sell it. You only owe 100K. And the median around your home is 500K. You just gained 400 racks in profit for selling your home. Let's say you add a new deck to it to build up the equity. Let's say you go get all tile hardwood floors. You upgrade the system. Now the equity went up 75,000. You sell the house for 550. You only owed 100 on it. That's 450,000. Hell, you can buy or put it. You want to get another home? You can. You got leverage. Or you want to buy a townhouse? You can buy a townhouse. You know, your kids are getting older. You want to buy a 3-bedroom townhouse? You got 450,000. The townhouse you want is 420. Hell, you got your asset. I mean, you just got so many things to do once you own it out. You got so many things to do. You could pass it on, leave it in the family. Isn't that what we want? Full ownership. Now you can put it in a trust. Now the trust owns it. Because the asset was owned directly by you with no liens attached to it. This is why it's beneficial to own the assets outright before you place it in a trust, because no outside creditors can touch it. Let's say you had to file for bankruptcy. Your house is outside the scope of bankruptcy, because just like the corporate finance company, you now have a bankruptcy remote entity to serve as the middleman that transfers it into the trust in a 2-step transaction. Oh, we're not going to get into the accounting and structuring today. We're not going to get into accounting and structuring trust structures. Oh no, let's not get into that today. Just because I don't talk about it like that, that don't mean I don't understand it or know it.
You're rocking with the best.
Does not act like it. Illustration from an active servicing file. From a matter reviewed this year. Figures rounded, identifiers withheld. A 5-figure sum was received and posted to the account and appeared in neither the payoff figure nor the reinstatement figure issued the same month. 2 identical fee amounts were carried inside an aggregate advance balance and then itemized separately in the same demand letter. An account analysis and a payoff letter issued 18 days apart stated the escrow position in opposite directions, one positive, one substantially advanced. 3 different current monthly payout amounts appear across 3 servicer-generated documents inside 26 days. Repeat late charges were assessed against a single installment where the instrument permits 1 per installment. None of these require an expert opinion about industry custom. Each resolves on the claimant's own records. Look at all these things we found. All these things we just found under this framework. This is what we found. All based off what? What they did. This is not a theory. We take what they produced, and now that is evidence. Your all the payments that you made, if they sent you a payoff quote, if they sent you an updated escrow balance, any custom activity account report, if they filed a judgment figures, or if they anything that they put a deficiency amount, and that why do you think I would be asking for that? Because it shows that I'm not building this just off a theory. I'm building your report based on evidence they found. You notice how in these spaces, they don't ever ask y'all for all those details, those intricate details, because the discharge template they're going to give you, all you doing is just signing your name and sending it in. They don't understand the nature. They don't even care to know. Remember, you pay, you get this document, you just send it in. Me, you pay, send me all your documents, and I built the report from the record. What if the company that they're giving that document, that discharge document, what if they seen hundreds of them already? You know, when it don't work, you know you're going to get the gaslight, the backpedaling. It worked for me. Oh, do your research. Oh, you must have, you know, it's always going to be your fault when it didn't work. It's never the teacher's fault when it didn't work. It's always you did. You could had them record it and do this. You did everything to the T. They will still find a way to say that you did something wrong. Or they send a severe balance due after you send that document, and most teachers going to tell you to ignore it. And you want to know what the teacher going to have you do next? The next stage of the process, they're going to have you do everything that what they can only comprehend, what they understand. Oh, that didn't work. All right, we're going to file a UCC1 now on the instrument. Oh, that didn't work. We're going to put the car in the trust now. That still ain't work. All right, we're going to change your status. Oh, that didn't work. Oh, we're going to file the 1099 now. That's all you're going to get. Oh, they're going to just keep, and none of what they're doing ever gets to the actual facts and circumstances of your case. This is why I don't have templates for sale, because everything I do is going to be based on each individual's own facts and circumstances, so it can't be duplicated. Your numbers are not going to look the same as the next numbers. This is why the 5 people that try to use my case and duplicate it, you can't, because that was so tailor-made to my case down to the numbers. And plus, I'm in a totally different state. My state allowed for the contract to be terminated, and they can't collect principal and interest. Some states, the interest just may be converted to principal. Many states don't allow for the contract to be terminated. That's going to play a factor too, which your state law allows. And these are the nuances and the factors that a lot of these teachers don't take in when they're trying to have a mass document apply across the board. It's impossible when everybody's situation is different. The only thing is consistent when you're dealing with a company that pulls and securitizes loans and mortgages and autos and credit card receivables is this framework right here. Because one thing about it, they don't differentiate between whether it's a credit card receivable, mortgage, or auto. No, that doesn't matter. Remember, the obligation starts off as an obligation on the note. Your obligation never ends there. The tricks they play that when it gets down to court, they're always going to go back to your original obligation under the note. They're not going to talk about how your obligation changed 3 or 4 times, depending on their structure. So in reality, you're never really obligated under the note. Your obligation under the note was converted into one or more other different obligations. And that's what I tracked during my investigative stage. And the note is not a promissory note after you sign it. It takes on multiple different characteristics, governed under multiple accounting guidance, governed under multiple rules. But when it gets to court, they're going to slap that same copy of the original note back in front of the judge. Talking about, this is where the obligation stopped right here. No, it didn't. And here's why it didn't. You think they will update you or send you a letter, let you know what's really going on after that? Absolutely not. This is why I say this is not built on speculation. It's not built on asking them for things that you don't may or may not know they have. This is all built on things that you already have to know. And you get your copy, so you'll be able to follow and break it down. And then in the future, you know, you'll be able to help someone else. So what you have, missing items do not stop the review. They become part of the finding, because a claimant who cannot produce the record supporting its own figure has a problem independent of the arithmetic. If they can't produce, that's another problem they have. That's a fact. Oh, we can't. Oh, we don't want to give you. Oh, you don't? Oh, shit. Okay. The contract and every amendment, modification, or change in terms notice. The most recent payoff, reinstatement, demand a deficiency statement with this date and who issued it. The complete transaction history or account history for the life of the account, not a summary. Every periodic statement you still have. If suit has been filed, the complaint, any affidavit of amounts due, and every exhibit attached to either. Strongly recommend. I strongly recommend you provide me the escrow or account analysis statement, proof of payments made, bank records, canceled items, confirmations, any information request response, dispute response, or correspondence about the balance. Any notice of transfer of servicing, assignment, or change of creditor. Oh, I love when I catch them in between servicers when they transfer the servicing. That's a whole nother accounting method. Oh, that's a whole. Oh, I love when they transfer the servicing. Oh yeah. Oh yeah. I love when they transfer the servicing. Oh yeah. Oh yeah. Oh, I love it. PDF is preferred. Photographs are acceptable if legible. Name files by date where you can. If a document exists but you cannot obtain it, say so and identify who holds it. That is itself a finding. These serve the God damn it. The report, the audit. Oh, and let me tell you this. This is not your typical securitization audit. You're not getting, hey, it's in the loan. I pulled the QSIP, and the QSIP says 100 million. Now you can file that QSIP with. I know many people. If I said that, they'd be running to the woodworks because in their mind, they get millions of dollars back and keep the house. I'm sorry, y'all. It's not the reality. I know there's plenty of y'all out there who purchased these securitization audits and you're still sitting on it to this day. The audit never got you the house or stopped or prevented the foreclosure. I know you have. This is not nowhere anywhere near that. Per account review, mortgage account, auto account, credit card account. It is too nifty, although it could be more. Depending on all the work and investigative and me breaking down every penny, could be more. $250 per review. Zelle, Cash App, Apple Pay. Please add $7 surcharges if you're using Zelle, Apple Pay. Write and find this memorandum with the transaction level schedule, each item tied to the page and the date in your own records. Mortgage accounts already in default are billed on delivery of findings, not advance. Meaning, if you have a mortgage account that's already in default, as soon as you send me the information, as soon as we're done with the report, I will send you the invoice and you pay if your mortgage is already in default. Yeah, if your mortgage is already in default, and you want it, you provide the information. I supply the report. I mean, do the report. When I'm done with the report, you just pay the $250 and you'll get your report. I wouldn't mind, but here's the thing. I don't mind doing the report first. I have no problem doing it. But you're not going to get your report until I get paid. I know it would be, hey, I do the report first. I send you the report, and then I got to wait for you to pay. I got to take your word that you're going to pay. Absolutely not. I don't think that would be, I wouldn't, nah. Part 1 dealt with the amount. Part 2 deals with the record behind it. Who holds the paper? Part 1 dealt with the amount. Part 2 deals with the record behind it. and how obligation moved from the party that created it to the party now demanding payment, and what has to be shown for that party to prove its claims. This stuff has already been proved, by the way. This is not even like, you know, this is standard operating procedures in our world. It's a standard operating procedures. Now, part of this right here. Hold on, let me acknowledge the gifters. Yep. Also, if you have a business, and you need your business account audited, all your profits, all your expenses, if you want me to help you strengthen your financial statement of position, let's say you're trying to go for corporate financing, I can move. I know I ain't gonna take y'all into it, but I know how to strengthen your financial position on the books. We're going to change your accounting method that you use to a more favorable one. If you are a cash basis accounting, meaning you count your income as it touches your hand and you count your expenses as you pay it, please reach out to me. We need to have a serious talk. How an obligation moved from the party that created it to the party now demanding payment, and what has to be shown for that party to prove its claims. A large industry sells consumers the claim that securitization voids the debt, that a note was destroyed on transfer, or that a borrower owns a beneficial interest in the securitization trust. Courts have rejected these consistently and have sanctioned parties for advancing them. We do not make these arguments and will not prepare a file that does. What follows is the narrow, documentary version that survives scrutiny and is materially stronger because it does. One thing about it, I cannot, in good faith, I don't give a damn if you offer me $500 or $1,000 to build a claim around what you believe is true. If it's already been rejected by the courts, I cannot, in good faith, put you in a position where it's going to harm you more. I've turned down so much money because people wanted me to pursue claims and use my accounting knowledge to substantiate their claims, and I just refuse to do it. I refuse to do it. I can't in good faith do it. Because what a lot of people, they think that when they reach out, my job is to support their assertions and claims. Actually, my job is to look out for what's in your best interest. So what's in your best interest may conflict to what you may want done now. I've gotten to a lot of goddamn Cujo, quiet down. I've gotten to a lot of heated and spirited discussions with clients because we disagreed on the way to go. And I stood on my position, they stood on theirs. And I said, okay, this is what you're going to do. Provide me case law or authoritative guidance that supports your claim. And it is when I say that they get in the passenger seat. Thank you. Now we can proceed. All right. Because I'm going to show mine. Now I need you to show yours. I know a lot of people say they follow the rules, and if the rules and the laws don't allow, they won't do it. That's not always true. That's not always true, because they come online They come online and they say that's what they do, but behind the scenes, they're sprinkling the twinge of that sovereign citizen stuff in it. It's a twinge. I can smell it. It's a twinge of it. Number one, transfer a negotiable instrument. An instrument payable to order is transferred by endorsement and delivery. The party seeking to enforce it must be able to show that the chain of endorsement reaches it on the face of the instrument, not by assertion. Now, here's the thing. This is a part where you have to be, the vague chain of endorsement. I see a lot of people just throw it out there, but I don't really think they understand it because there's intricacies that are involved with that. The complete chain of endorsement, it's not always going to be based on assertion or what they filed in court. A complete chain of endorsement, it's another set of rules and documents that govern a complete chain of endorsement. These will never be filed in court to prove that they have a complete chain of endorsement. So this is the trick that they're getting by. They're using the possession of the note thing. So whoever's in possession of it can enforce it. That's what they're doing. But this is what gets back to the corporate finance side, the regulatory side, and the investor lens. All these companies have already agreed to the transfer. And remember, I'm getting in set use. I'm getting in hot water. I know my group members are not. They're gonna get mad if I say this loud, because they be like, "Damn, why you coming on live saying this live?" And we had to pay to be in the class. So yeah, it's only fair to them. No, I can't do that to them. But I'll just say this: a lot of people are missing that part right there, because a lot of people are thinking that the transfer has a lot of different meanings. And they know a lot of people not breaking that. It's not that cut and dry where, oh, you didn't it's nuancing. And this is one of the things where the SEC attorney told me, this is why I was, this is one of the things like, yo, a lot of people missed this stage here. And I can't really get into detail right now, but you got to read between the lines. If you want the full unredacted and complete breakdown,
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby, folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
a missing link. The instrument runs from the originator to the current claimant, while the recorded transfer history shows an intervening party who never endorsed. An endorsement by a stranger to a chain and a launch signed by an entity that appears nowhere else in the file. In timing, an endorsement or a launch executed after the suit was filed or executed on behalf of an entity that had merely merged or dissolved. Standing is measured as the date the case was commenced. None of this is exotic. It is documentary. It is testable from the file, and it is the version of the argument that judges actually entertain. Now, when they file the original note, they're always going to do like some certification of when they possess the note. But I know that there's other certification, other documents that they have to produce to actually prove that they're actually in possession of the original note. A copy of the original note is not the original note. See, the problem, this is the trick. They don't have to produce the original note in wet ink signature to you. That's the whole thing. They don't have to produce it to you. It's impossible for them to produce it to you. They can't produce it to you because it has to be somewhere else. So when you ask them for a copy of the original wet ink signature, that disrupts their operations. So the government in the secondary market came and whispered in the court's ear, and they created that clause in your application for your mortgage and in your deed of trust. By signing the application, you have assented to the electronic version of the note, aka the copy of it. By signing the application, you have waived any later argument in court from it. This is why those arguments fail. The reason why it's like that, because it is a condition of you getting the financing. You get what I'm saying? That's just how the game goes. By producing a wet ink signature original note to you, that means it's not where it's supposed to be. That note is going to be where it's supposed to be, whether you like it or not. So there was never going to pass a law or requirement in the courts. Once they breathed in the court's ears, this is the part of the game where the system is bigger than you and I. The system is bigger than you and I. This is one of those things where it is what it is. I wouldn't make a big fuss out of it. It is what it is. Not saying we're giving up the fight, but you have to pick and choose your battles wisely. Some of us spend so much time fighting useless battles after we've already lost the war. Two, the program requirements overlay. Where an obligation sits inside a government-related mortgage, the program's own guidance poses documentary requirements on the participating situation. Those requirements are contractual undertakings, and they generate testable expectations about what the file should contain. Program guides typically require a complete chain of endorsement from the originator lender through the issuing institution, ending in a specified form, where the file shows blank instead of one or two things is true, and both are worth knowing. Custody is ordinarily held by an approved third-party document custodian rather than by the party servicing the account. Where the claimant is not the custodian, the question becomes, and that's the question I blocked out. That's for my clients. The investor designation appearing on servicing records can be compared against, that's blocked out too. A mismatch between the designation of the records and the documents in the file is a discrete answerable question. We do not present these as conclusions. We present them as requests that the claimant is obliged to be able to answer, especially when we already know what you had to file, what they had to file. The documents they had to file is never going to be in the original file in the complaints file. It's never going to be there. Oh, it's never going to be there. Oh, no. You ain't got to worry about that. Book entry and holdings and its limits. Modern securities are held indirectly. An investor typically holds a security entitlement against its own intermediary rather than a certificate. This is the part of the securities world that a lot of people don't understand. When you think that securities world has been so convoluted and destroyed in these pro se spaces, it never functions the way they say it does online. They have no clue. They haven't even seen a security held in book form. They've never seen it. I've seen that shit on my uncle's computers, all the commercial paper he holds. He never gets the physical copy because there's not one to give. He is an investor. He buys MBSs, ABS. He buys them. I've seen what it looks like on his office computer. Like there's no physical copy he gets. You think it's securities like tangible because we got this this literal interpretation of everything that we read. An investor typically holds a security entitlement against its own intermediary rather than a certificate, and interests are recorded on the books of successive intermediaries. That's a fact. I've seen it with my own eyes. That's what I'm saying. Y'all getting information from people who hasn't lived in this world, on this side of the fence, or knows people who actively operate from this side of the fence. 99% of online, it's all theories and beliefs. They're not in these spaces. They don't know people in these spaces in real life. They don't know attorneys. They don't know Series 7 securities brokers. They don't even know people who purchase commercial paper. They don't know people who does these structures and these fundings. It's all theories and beliefs, and that's what they're selling to you. They're selling everything you want to hear back to you in tangible form, and it's all good until it's not good. They never question them. They never ask the important questions to the people who have no clue what's going on. But to the people who understand the system, they got 5,000 questions and want all these reassurances. Well, you should have had that mindset from the beginning. The system is frequently invoked by consumers, almost always incorrectly. Under the uniform commercial rules governing investment property, an entitlement holder's interest is enforceable against its own securities intermediary, and generally not against third parties. And the framework expressly rejects tracing specific assets through successive holders. A borrower is not an entitlement holder. A borrower has no security account, no intermediary, and no entitlement. Why we tell you this? Understanding the book entry system is what stops a case from being built on an argument that cannot win. Its legitimate use is explanatory. It tells you who holds what, why a custodian rather than a servicer is likely to hold the instrument, and which questions have real answers. It is not a source of borrowers' rights against a trust. And any analysis who tells you otherwise is selling something. They're lying to you. Don't leave now. You cannot just plug your ears when you hear something that goes against what you've been taught, what you believe. Why don't you just hear it all out first? Why is it that the immediate thing has to be, he must be wrong, he don't know what he's talking about? Why can't it be, well, hold on, I thought that's exactly what I believe. Could I be wrong? It can never be. We never want to question whether we're right or wrong. It's always, I gotta be wrong. Everybody that comments and says that I'm wrong, you're commenting, saying it because I'm saying something that goes against probably what you've already paid for, what you believe, or what you're already in the pot against. But you keep trying to think you're getting some proceeds out these securitization trusts. That is nothing more than a theory expounded by the sovereign citizen patriot community. Because remember, the framework is they always want you to look for ways to extract money out the system. Whether it's through a lawsuit, a manufacturer bad faith FDCPA, FCRA claim, or just pretty much filing a lawsuit, and one of your claims for relief is proceeds from the securitization vehicle. I see that in damn near all the pro se lawsuits they file. They always mention a securitization vehicle, like they're going really getting money out of it. The only reason why they even filing a lawsuit is because they're in hopes of getting free money out the situation. That's it, y'all. That's it. Application by account type: mortgage, advance and fee reconstruction against the securities instrument, authorized charge provisions, escrow, disbursement against advances, shortage and surplus computation, analysis statement consistency, comparison of servicing record designations against blank, reconciliation of payoff, reinstatement and account history figures issued within the same period, auto and other security installment, decomposition of the disclosed finance charge and the itemization of amounts financed, identifying components that reflect costs of parties other than the borrowers. And that's one of the things I specialize, decomposing the finance charge, the APR, and letting you know where your money's actually going. Examination of how the transaction is classified on the funder's own books, including whether the receivable is recognized as, let's get past that. Post-default, repossession accounting, commercial reasonableness of disposition, proceeds application, and deficiency computation, auxiliary products, service and contracts, gap coverage, insurance, traced from wholesale costs to the amount charged to the borrower. Come on, man. Y'all know this is in depth. I'm just giving you an overview of what you're getting. This is an overview of what you're getting. It's not like, hey, I got this say here, just come get it because it's gonna 1,000%. You're gonna win every single case with it. Everybody's gonna stop it. Then I don't know. See, that's what they wanted me to advertise, because everybody's looking for 100% guarantees in these spaces. You don't look for 100% guarantees in any other facet in your life. Credit card and revolving. Reconstruction of the balance from the earliest available statement forward, tested against the cardholder agreement in effect. Interest recomputation. We recomputing the interest against the disclosed method and rate, including penalty rate application and any change in terms notice. Fee assessment against the agreement's fee schedule with attention to blank. This is better than getting sued for a credit card balance that you know you owe, that you know you swiped the account, and then looking for any reason to file a suit against them, or waiting. Hopefully you can get them in court because of faulty documents. This, you can still get them in court, but this is arming you with evidence from their own record. They can't get around it. Where the account has been sold, completeness of the transfer record, and whether the balance claim matches the balance transferred. That's corporate finance side. That's the corporate finance. What this does to a judgment figure. The practical consequences stated plainly. A summary offered to prove an amount due must reconcile to the records it summarizes. Where it does not, it is not competent proof of that amount. Where the underlying entries were created on a third-party system, the witness offering them must be able to explain how those entries were made. Frequently, the witness cannot. Where the claimed amount includes charges the contract does not authorize, the overstatement is not merely a defense. In many circumstances, misstating the character or amount of an obligation is independently actionable, and several of the relevant statutes shift attorneys' fees. So for you consumer law people, this will be like a Mac 10 in your hand. Instead of, oh, robocalling, or you didn't respond within 30 days, or you didn't, instead of all those normal consumer, you got from your own record, this is how you violated the consumer statutes. This is from your own record. We quantify. Your attorney decides which one of these apply and how to plead them. Or, I know there's a lot of pro se people here. What you would need, In addition to Part 1 list for chain of transfer analysis, the original contract or note is executed, all pages, including the reverse of any page bearing endorsements, any allonge, endorsement page, assignment, or transfer document, including anything filed as an exhibit in a lawsuit, every notice of transfer, sale, assignment, or change of servicer you have received, with dates, any recorded instrument affecting the account and its recording data. If suit is filed, the complaint and every exhibit in any affidavit or certification about ownership or possession, any response you receive to a written information request or disputes. Same as other 250 for the account. Analysis on this report review have been reviewed by a senior audit professional at the Big Four accounting firm by former Security Exchange Commission's attorneys. This has been signed, sealed, and God damn it, stamped by professionals. Because I run everything by them before I be like, hey, it's good. And guess what? Do I want to show? No. I was about to do. I'll throw that in for a bonus. Cause I'll let you see what I sent to Equifax and Experian. I'll let you see what Equifax and Experian. Darren, you've already seen that one from Equifax and Experian. The Supreme League team. You've seen it already. Very powerful. Very, very powerful. Give me 1 second, TikTok. All right, I'm back. So I'm going to open. I'm gonna open up. I'm gonna open it up. The panel for right now. TikTok. I'm going to open it up. The panel right now. If anybody wants to join, got any questions? If you got any questions, you got any comments, you can request to join. If you want to, you can. If you have any questions you want to ask. But if you're doubting, we got a little reserve. Let me do the playback for you.
According to your conversation with your friend, the attorney, what we go over in group is right in line with the legal standards and the professionalism on how it has to look and what you need to know when you attack these people.
The words that he used was, you're going about it standard operating procedures.
SOP. Standard. I have one more coming up. I'm going to show you how this, I forgot to do it, but I'm going to actually give you how this framework, the hidden figures, where we break down your numbers. If there's certain imbalance, get you judgment. And if you're a credit report, FCRA, fair credit reporting, yeah. If you want, I know the credit report people, credit and disputing. I have a credit report dispute from, not only he is a litigator himself, but his friends with the ex-SE attorney, 27-year decorated career, and the ex-head, one of the head people that work for Deloitte, one of the Big Four accounting. He actually taught a class in my group about the how to bring an FDCPA claim, fair credit reporting. If you want to view that class he taught, you send me a DM or you can send me an email. I will place you in that group. You will be able to watch that group at your leisure. You'll be able to take notes and you will be able to produce your own. You will be able to produce your own claim. You'll be able to do it. I've utilized it. I've gotten big results from it. That, and along with the framework I teach and set you, if you want it, watch the video for however long as you need. And it's a whole breakdown class on the regulations, the rules, everything professionally brought down. And no, it's not just your normal consumer laws. He broke it down. Everything you need. Kind of read like a damn discovery, like you in court. The way he broke it down, it was an excellent class. Excellent. You can watch that video. I don't have templates to go with it, but it arms you so you'll learn how to do it yourself. That video is a powerful video. Now, I don't teach credit repair. I don't do that. I just utilize the framework from my accountant, and I get a lot of things done on that side with the Experian and all that. But I don't teach it. But I know it stops it dead in its tracks because the amount due, like let's say in credit reporting, the amount due is always going to be inaccurate under this framework. It's going to be accurate regardless. We're attacked there. And this, allowed you. So get into the group. I'll have the video posted on Telegram. And you can watch it for however long you want. You'll be able to view it on Telegram. It is not downloadable. It's not downloadable. You don't own the rights. You can watch it being taught from a professional. And the charts and the way he broke it down, he's also a day trader too. He trades on the secondary markets, Euro clear. So I'm able to find out a lot of stuff that people paying for securities for. He can track it. I mean, those audits, he can track it. Euro clear and all that. All right, so if you want to be in that class, well, it was already taught. It was in my archives though. If you want to be in, if you wanted to be in that class, you can send me an email, Thomas Legacy 603, send me a DM, and you don't have to. I know it's gonna put aside these credit report gurus, but shit, what you'll be able to do it on your own. I'm confident you'll be able to do it on your own. Or if you're already doing it, it'll strengthen your repertoire. See, a lot of people, I always like to add. I don't care how strong my claims are. If there's some new information, I always want to add on. I want to add on, strengthen it up even more. And 1 second, TikTok, and I will get this, the court side, the legal side. I forgot to tie it in how this is supported in legal actions. Yep, give me 1 second. YouTube, I am queuing it up. I forgot to transfer it, so just give me 1 second.
Run it up. I'm in the kitchen cooking up something new.
1 second.
She's singing along to our favorite tune. Wow. Enjoying the breeze from Toronto. They admire my watch at the show. You seem like you had something to share. What's up? I thought so. Okay. I'm back in this game, now you're waiting on the bench. I thought so. Okay. He's back in this place like he had left something behind. Celebration for tonight. I'm feeling ready for the night.
All right.
Confidence high, we making moments to remember. And leaving behind the worries, moving forward, favor. Got a plan but no rush, just taking it slower and better. Embracing the job with friend and enjoy. Right. My confidence.
You're rocking with the best.
All right. Got to add this part. My bad, y'all. I said I can't let you go without letting you know how this works in the legal sense. The case law behind the method, the authority report, decided authority supporting and limiting the hidden figures analysis. This report collects the decisions that made forensic accounting analysis worth doing. It is organized the way a case is actually built. First, the evidentiary rules that force a claimant to prove its number. Then the substantive law that makes an unsupported number actionable. And finally, in the same detail, the theories that lose. Citation offer research, not as legal advice. The analysis prepared, it's not practice law. So gotta give you that. Not a lawyer. Part 1. The claimant must prove its number. As you can see in the Loan Depot, we had a whole script. We went through like the first page of cross-examining the witness. And then when we got to the numbers, I said, take that script and fling it across the room. We're going to play the rest of this by ear. And you know, it's oh gosh, because court, they're talking and moves fast. So I got a text and hope she gets it right then and there. Because I told her, keep watching your phone the whole time. Yeah, get your, he's recording, but watch your phone. Watch your phone. I know you get it. Keep checking your phone. So if there's something I need her to do, I got to text it or I got to say it in the back ear. I can't say that while she's talking because, I'm on mute. So then you probably heard in the video me, like you can vaguely hear me in the background. That's me talking, relaying information to him. No, ask about this. Go back here. Ask about this. Oh, no. Okay, counter with this. Counter with it'd be like, God damn, sometimes I wish I would just right there. The starting point is that a claim balance is hearsay. It comes into evidence only through the business records exception, and only if a witness can lay the foundation. When the lawyer wanted to introduce the judgment figures into the record, I immediately texted and said, object. She didn't look down at the phone in time. Because if she would have objected before we got into that long dialogue, I believe the judge would have denied his entry into the evidence. See, that's the whole thing. Because I mean, come on now. Because they was asking questions, they was done with their questions. And as soon, I think she did object, I think afterwards, and the judge was like, oh, it's just showing, the figures, what they saying they have to prove. So it was some shit. I gotta talk to her about it. Because that wasn't in recording. Only a witness can lay the foundation. Where the number was generated on someone else's system, that foundation is frequently unavailable. Now, remember when I said I had to make a phone call to had to dig deep in the resources. And I said, remember, I was like, yo, I've seen this document somewhere. Can you please show me if you have this document or know I could find the same account printout from another company besides Loan Depot? Man, when he responded, he said, you mean this document? And it said another servicer but the same format and the same count, the same boxes. I said, I just got manna from heaven. I just got manna from heaven. Now it shows that this wasn't your original system. Oh, I got manna from heaven. I got manna from heaven using a third party. Oh, I got the direct evidence. One says loan pile, the same identical document. It says another servicer. Gotcha. Gotcha. Using the actual form, just a different servicer that's in it as evidence against them.
You're rocking with the best.
When I create evidence, it sticks. They can never get around the evidence. The foundation requirement, Florida, Yisrael versus state, the holding, it sets the 4 elements a proponent must establish through a records custodian or other qualified witness. The record was made at or near the time of the event by or from information transmitted by a person with knowledge, kept in the ordinary course of a regularly conducted business activity, and it was the regular practice of that business to make such a record. The checklist every servicer witness is measured against. For each element is a separate question on cross. Glare versus National Bank. And holding an affidavit of indebtedness was inadmissible hearsay where the affiant did not know who made the data entries, how, or when. Now, if you got a document that's generated by a third party, which I know who is generated by, how can you know who made the data entries, how, or when? Cannot say the records were made in the regular course of business and relied in part on data from a prior servicer whose procedures he knew even less about. The court held he had no knowledge of how its own company's data was produced and was not competent to authenticate it. Because no competent evidence supported the amount, judgment was reversed. You see how, even though see how, why the appellate courts have jobs? Now, I wonder how Loan Depot is going to respond now to my brand new motion to strike. Both Exhibit 5s entered and strike Dennis Bush's testimony at the trial June 12th. Newly discovered evidence. The central case, note precisely what it turns on. Not that the debt was invalid, but that the amount was unproven. That is the same posture a reconciliation creates. Remember, we don't argue that we don't owe the debt. At this stage, it's irrelevant. We attack the system that created the debt numbers first, and then in turn, attacking the debt itself. We don't have to get into I don't owe it. Matter of fact, that's not, we ain't got that. We got the better argument is these amounts, you can't approve these amounts. These amounts are inaccurate. Hunter versus all loan services. Holding, absent personal knowledge of the prior servicer's procedures, the witness cannot lay the predicate for business records exception, directly applicable wherever service and that's transferred, which is most files. Holt versus Kaches. Holding, reaffirm the requirement that a witness relying on a prior servicer's records have knowledge of that servicer's record-keeping procedures. Confirms Glarum was not an outlier confined to its facts. Yang versus Sebastian Lakes Condominium Services. Holding, a witness from a successor management company lacked personal knowledge of the prior company's practice and had no way of knowing whether data obtained for that company was accurate. It extends the principles beyond mortgages to any successor record situation, useful for assigned auto and card accounts. The counter authority before part 1A. Any analysis who presents the foundation cases without the cases cutting the other way is setting a client up. Opposing counsel will cite these, and they are good law. See, we even with the opposing counsel may cite. Distinguish glarum and permitted admission of records where the witness could supply the missing foundation. Glarum's own footnote states that there is no per se rule precluding admission of computerized business records acquired from a prior loan servicer, and that the client need not be the person who entered the data. Yes. The honest limit. Foundation failures are proved case by case from the witness's actual testimony. They're not automatic. This is why everything we do comes from the record instead of a generalized application across everybody, regardless if you're in a mortgage, auto, or credit card case. It comes from that's why I say your records, what's been on the record, what's been filed. It's built from that. That's why everybody's is going to look 100% differently. This person, we may find it hidden in advances. This person, everything looks fine, but we found it in the escrow. This person, everything from the origination to closing was good, but it came into the application of the fees and stuff here. All of it is going to rest on each one's facts and circumstances. This is why I love what I do, because everybody gets their own work in their own unique form, tailored directly to them. You can't duplicate my work. Ask the 5 people who tried to duplicate my credit acceptance success and ask them, why did they all 5 lose, and why did I win? Deutsche Bank versus Fries. A loan servicer may lawfully rely on the records of a prior loan servicer where the proper predicate is established. Expect this citation in response. The answer is not that reliance is impermissible, but that the witness did not establish the predicate. That's what we attack, the predicate, the foundation. Jackson versus Household Finance Corp. Addressing the standard for admitting business records and the qualification of the sponsoring witness. Controlling Florida authority must be consulted before framing any foundation argument in that state. That's why it's going to go from state to state. That's why you're going to get the case laws from your state. I can't apply Massachusetts to Texas. You ever seen gurus online? They're clearly from Texas, but they'll be citing an Alabama case. Like, that means everybody that's in your live must be from Alabama. You notice how they don't understand case law? Prime example, Ellis Raspberry in his lawsuit, he was citing cases that wasn't even in Georgia. He was citing cases from Philadelphia, and this is how far this is how when you're dealing with rookie case researchers, all their cases is going to be some wall cases, 1787, some wheat cases, 1854, or the Quaker cases, 1822. You're in 2026. You want to know why? Because they can't find any case law within the past 70 years that recognize their claims. That's why they all go back to the ancient early 1900 cases. And they're always going to cite 2 or 3 of the same cases throughout their whole complaint. Not that servicer records are inadmissible. The claim is wrong and the client who advances it will lose. What it establishes that admissibility depends on testimony a particular witness either can or cannot give, and that a reconciliation identifying specific unexplained entries is what forces the witness to try. Notice how in the video they kept trying to get the numbers right, those awkward pauses. She brought her back on the screen multiple times to testify and still couldn't get it right. Now, I don't know what I'm talking about, though. Georgia has developed an unusually favorable line for defendants on proof of amounts and proof of assignment. Sanders versus TD Auto Finance. Judgment reversed. Why did you reverse the judgment if you're supposed to get it right the first time? This is why I don't believe these 100% wins. You've been in cases long enough, you understand why the appellate courts have jobs. If you're just starting out and you got a template and Midland ain't want to pursue it anymore and they dismiss their own case, I know your chest is puffed out like, oh yeah, I know what I'm doing now. It's going to work every time. Step your ass up to the lane I'm in. Autos and mortgages. Step your lane up to $400,000 mortgages, $800,000 mortgages, $1.8 million commercial transactions. Step your ass up there and you're going to really understand how tedious this job really is. And this is why you can tell, because when it gets to mortgages, it's always a discharge method for a mortgage. You notice that it's never really litigation support. It's always, I'm a discharge a mortgage with a promissory note. I'm a discharge a mortgage with this. I'm a discharge a mortgage with this. They don't really have real litigation support. You would think the average guru online can take all the mortgages records, the service of records, and literally break down their numbers to the penny. You really think they can do that? They don't even have enough understanding of that system to offer it. The loss mitigation specialist affidavit statement that the dealer had assigned a contract was inadmissible hearsay because it rested on her review of records rather than personal knowledge. She was not employed at the time of the assignment. Testimony about the contents of business records, unsupported by the records themselves, by one without personal knowledge, is inadmissible hearsay. The strongest auto deficiency case in this collection: 2 independent failures, no written assignment, and an affidavit that could not substitute for one. Nyankojo? Yeah, this was a good one here. Nyankojo? Because somebody tell Nyankojo to get in here. Versus North Star Capital Acquisition. Refused to uphold an assignment where the documents produced did not affirmatively link the assigned account to the same account number as the original account. Computer-generated information tended to show an assignment for which no foundation was laid by a witness was inadmissible hearsay. The account number linkage point is a concrete, checkable item in every purchase debt file. Capital City Developers LLC versus Bank of North Georgia. Summarized statements of account submitted to support the amount of indebtedness were inadmissible under the business records exception, directly on the aggregate summary problem. A summary itself is not self-proven. You think I give a damn because you have a summary of the... Thank you. I'm going to use that as evidence against you. Thank you. Prot Shell versus River City Bank. Affidavits purported to establish the amount of a debt without the accompanying business records were appropriate are insufficient to sustain summary judgment. Inadmissibility on summary judgment is governed by the ordinary rules of evidence. Use where affidavit of amounts is due is offered without the underlying transaction history. So many pro se litigants in this space have to learn how they go as they go. It is at an alarming rate when a pro se litigant sends me their stuff to review. It's always their second or third amended complaint. A lot of them get it wrong at the beginning, and it's not uncommon because when you're new and you're fighting your case for the first time, you are going to go by what others taught you. in which you were sold. Many pro se litigants never consult the court rules, procedure, case law, because there's no need for them to do it in their real lives. So when you're in a legal situation, you pretty much have to cram years of studying, years of understanding, and experience of being inside of a courtroom into that time frame of your litigation. The number one problem from a lot of pro se litigants in this space is they don't have the experience. So they think all their claims are sufficient, but even down to how you word the claims, how you assert the claims, and it's merging the statutory law with, I can see a lot of what circulates in it, in these spaces. Brown versus Service Credit Union. Witness failed to lay proper foundation under Rule 8036. Their testimony based on those records was inadmissible hearsay that should not have been considered by the trial court. Recent application of the same rule, because it is new, verify the public citation in subsequent history. So y'all gotta, I would verify, all this. But this is a new case, 2025. An unauthorized charge is independently actionable. Part 1 keeps a number out of evidence. Part 2 turns the same find into affirmative claim carrying statutory damages and fee shifting, which is where the settlement leverage comes from. Since they applied unauthorized charges to one account, my client in the Loan Depot case now has a actionable charge against them under the consumer laws, just by going over and auditing the record, finding the hidden figures, which is the subject of this live. The ledger, exposing the hidden figures. Kmart versus Bank of America. A foreclosure complaint listing not yet incurred flat fees as due and owing stated an actionable misrepresentation. The mortgage authorized charges for services performed in connection with default and expenses incurred. Read through the least sophisticated consumer lens, the law firm was not authorized to collect for services not yet performed. Violations pleaded under 15 U.S.C. Look at you, 1692E. There go, yeah, there you go. 2A, 5, and 10 in 1692F. There you go. The court rejected the argument that a court filing is outside the FDCPA's reach. What is that saying? They filed it on the record. We can actually file a suit against them for that misrepresentation and unauthorized charges. You see how auditing the record starts to open up a plethora of lanes that you can drive your claims through just by having that report. Oh, I got an FDCPA claim here. I got an FCRA claim here. The single most useful case for this service, the distinction between fees incurred and fees anticipated, is exactly what a ledger reconciliation exposes. You notice how we caught them. Here's another, charging 4 late fees to 1 installment period on 4 different dates. That's the first one. What's the second one? Burying attorney's fees inside of your corporate advances while simultaneously seeking a different set of attorney's fees, burying $3,900 inside of the corporate advances while separately seeking the same $3,900 as attorney fees. Caught you in the double up. Ain't that a consumer FDCPA claim? All from what? Auditing the record. This is revolutionary. Think about it. You're in a mortgage case. Let's stick to mortgage for a second. Your record's audited. Find the hidden fees, all this stuff not authorized by the contract. Violates your consumer laws. Now you have a consumer claim lawsuit against them at the same time. They trying to, file against you. And yours is built off the record. Don't you think that forces leverage and resolution in your mortgage case? I'm not looking at it to be like, hey, I'm gonna go get $1,000 from them. Because let's say you get awarded $1,000. That don't stop your mortgage. All they're gonna do is deduct $1,000 from what you owe. Nah, see, I'm looking at that as leverage and resolving the mortgage. Those violations and bringing that lawsuit, it's just leverage. And since the damages are high in her case, because I found a plethora of violations based off the record. Remember the activity, the judgment figures, and they testified that it was their original? What is that, false and misleading statements? And you said that this came from yours. This is on the trial transcript. It came from y'all, Loan Depot. And then I found the same form that another servicer used. Shout out to my connect. Damn. You see how it's starting to snowball on them? And they don't even know it yet. Y'all know. They don't know yet. Bradley versus Franken Collection Services. A collector violated 1692F by collecting a flat 33 and 1/3 collection fee where the agreement created the debt authorized on the actual cost of collection. The fee was assessed before collection work was performed, so it did not reflect actual costs. Controlling in Georgia, Florida, and Alabama, the principle generalizes a percentage or flat fee is not a cost, and an agreement authorizing cost does not authorize a markup. 15 USC 1692E 2A, false representation of the character, amount, or legal status of any debt. Strict liability. Intent is not an element. Man, with this audit, I will spank them all under this statute. If I was a big consumer guy. See, I use set you. What I teach is set you, and I will smash them all across the board of consumer violations. You know what? Darren, what you think, man? What you think? Because I know that you robo-signed and you didn't respond in time. These consumer claims, it's actually being built from their own mouths, their own words, their own records. I don't know, man. This is an easy one. This is an easy one. This would be so easy. Fair Credit reported at, oh my gosh, what is it again? False representation of the character, amount, or legal status of any debt. Are you serious? You're charging me things that you agreed with another party to charge to me that's not authorized by the contract, but you're hiding it under fees and advances. That's a false representation of the character of the debt. You're making it seem like it's a consumer debt when it's your corporate debt. Set you would spank them on the consumer lawsuits, FDCPA claims. Oh my God. Good God Almighty.
You're rocking with the best.
Good gracious. 15 USC 1692F. Look, there you go. Collection of any amount, including interest, fee, charge, or expense incidental to the principal obligation, unless expressly authorized by the agreement creating the debt or permitted by law. Well, the agreement that you are charging these extra fees to my client was not created by the mortgage agreement. It was created by your separate agreement, which I have evidence of. That's a 1692F violation itself. Oh my gosh. This is crazy. Damn. Shit. The collection law firm. Who is that? That's Loan, EXL Los, EXL, that law firm. I will, because the mortgage, the mortgage, the servicer may be outside the scope of the FDCPA, but that goddamn law firm ain't. Then the law firm will go back to them like, look, y'all motherfuckers gave us these numbers. See how it trickles down to them? We spanked the law firm. We sue the law firm. The law firm gonna go back to them like, hold on, man. Y'all need to do something, motherfucker. We got these numbers from y'all. See how we caused the confusion with them? Oh, yeah. I see what I'm doing this week. Just to mess with them. I'm gonna put together FDCPA. Look, are you credit people? I'm gonna show you how to put one together that's built off the set you teachings. I'm gonna show you how to put one together. All these FDCPA claims, I don't see them winning in mad. I'll be a few far in between. I'm gonna show you how the FDCPA under the set you teachers and guidance, how that flows, what it looks like. We're gonna break every number, miscalculated number, everything from the record is a violation. Note that the structural fit, section 1692F, asks exactly the question the authority layer of the analysis seeks. Does the contract permit this charge? Well, that's what my auditing service asks. Does the contract permit this charge? I have direct evidence from you that the contract doesn't permit this charge because this charge was related to a separate contract that wasn't part of the loan agreement. That's a violation there. The accounting work and the statutory elements are the same inquiry. We're asking the same thing. You know what? I'm gonna F with the law firm for Loan Depot. We're gonna bring a suit against. We're gonna F with them just to cause confusion. We ain't really looking for no $1,000. We ain't looking for nothing. I mean, I guess you gotta plead it, right? I guess, but that's not what we're looking for. We looking to cause. We looking to start have them beefing amongst each other now. And it's basically a law firm. This ain't really against y'all. We using y'all to get through to them. They gave you the numbers. We know you about to go back and get on about putting y'all under the gun. Now they got to help y'all out. So they got to come to her because they don't want to throw the law firm can't be thrown under the bus for their own records. So now it forces the conversation to shift back in our favor. FDCPA governs debt collectors. A creditor collecting its own debt in its own name is generally outside, and a mortgage servicer status depends on when servicing was required relative to default. Well, hold on now. Loan Depot, you never produced evidence on the record that showed that how you legally reacquired the note. We know where the note was at. It went to Guinea May. You didn't produce evidence and records to show how you reacquired the note. So you could be trying to collect on behalf of them still. Your ass might be a defendant too. Or we may let the judge see if you're really the original creditor or not, because that's where the question would come down to. You're the original creditor, right? Well, I'm going to produce to the courts all the documents that you didn't file when you filed the complaint to show that you reacquired the note as its rightful owner. Now you got to answer the question now. Uh-oh. I think I just might add y'all to it just to spice in the pot. The collection law firm, however, is squarely covered, which is why the fee entries traceable to counsel are often the most productive line in the ledger. EXL Los, whatever your law firm name, we already caught y'all trying to double dip. We caught that $3,900 under the advances, and then the same amount separately as attorney's fees. Yeah, we already got you there. Yeah, we're going to add Loan Depot to it just to F around. You're the original creditor, Loan Depot. Well, you should be able to prove that you are against evidence proving that you're not. Oh, I love the way it comes together.
You're rocking with the best.
See, I'm getting ideas too by just talking to you. I'm getting ideas too. Ideas just floating around. Mortgage servicing, the error resolution route. Renfo versus Nation Star. A borrower stated a respite claim where the servicer responded to her notice of error by only denying error without a written explanation of the reasons for its determination as required by 12 U.S.C. 2605 and 12 CFR 102435. That failure supported an inference the investigation was unreasonable, which in turn prevented discovery and correction of an account error. Damages were adequately pleaded where the unreasonable investigation cost her a refund of overpayments. This establishes the mechanism. A documented specific notice of error that the servicer answers with boilerplate itself is the violation. A reconciliation is what makes the notice specific enough to require a real answer, especially when you're resping your notice of error. You're asking for reconciliation and explanation built from everything that you filed on the record, Loan Depot. So you can't sit there and say, oh, we don't know, we can't respond to this because you already put it on the record. We're just asking you to explain your double dipping. Because if you explain your double dipping in the response, but you didn't explain it in court, now we got some explaining to do. Caught them right with a notice of error mid-litigation, already after you already put it on the record, already after you couldn't explain it in open court. Hey! You talking about timing. What did I tell you about court? Court is about timing. She came to me like February, end of February, going into March. We didn't even file the notice of error until a couple days ago. See what happened if I'd have filed it prematurely before the evidentiary hearing? Timing. That's the first thing people want to do. All right, notice of error. No. Slow your roll. Slow your roll. Timing. Problem with pro se litigants in this space, they are impatient. They are impatient. They don't understand the art of timing. They want everything there now. Timing. Brene versus Nation Star. Both limit reinforce. Both limit Renfro. Damages are an essential element of a respite claim. Where the servicer refunded the erroneous charges, the borrower cannot show actual damages. So they refunded the erroneous charges and you still filed a respite? And the borrower must have asked for a remedy the statute actually authorizes. Rescinding a foreclosure sale is not a must. See, that's the problem. They think that's going to get you out of the... No. Mortgages are tricky. It requires a lot of leverage, just like autos. It requires a lot of leverage. It requires you uncovering their dirty little secret. It requires more than just, man, I don't know. The realistic frame. A notice of error is not a magic key. It works where real, quantified, uncorrected overcharge exists, which is precisely what this analysis produces. You can't explain over 20,000 of overcharges that you can't explain. I think it's $20,068.50, somewhere around there. Charges that were in your exhibits in court, but wasn't on the borrower's customer activity sheet. We just asked you to explain it. I'm more interested in them explaining it rather than actually trying to sue on a RESPA. But you notice once again, FDCPAs limited to third-party debt collectors, RESPAs limited to servicing. You notice how there's nothing on the books that attacks the actual corporate finance side of our consumer transactions because it doesn't exist. You think they will actually have, that's what I'm saying. These are very limited scope stuff. That's what I'm saying. The consumer laws, it does more to protect the engine than it does to protect our rights. That's why I'm not a big fan of it. But I think I'm going to use it here as leverage. The theories below are not merely weak. They have produced sanctions against people who advanced them. Any consultant, auditor, or analysis who built a client's file around them is exposing that client to a fee awards on top of the underlying judgment. This firm does not prepare work products supporting these arguments. Ames versus JP Morgan, 2016. Debtors generally lack standing to challenge the assignment of their security deeds. The security deed afforded the debtors no right to dispute the assignment. And in making and receiving the assignment, neither the original holder nor the assignee breach any duty to the debtors. Dispositive in Georgia, a borrower cannot attack the assignment itself. Note what survives. Ames expressly preserves the duty to exercise a power of sale fairly, including compliance with statutory and contractual notice requirements. See Georgia Statute 232114 in the wrongful foreclosure line. Welk versus GMAC Mortgage. Welk versus Ally, both of them. 13 claims resting on a show me the note theory were dismissed and counsel was sanctioned sua sponte under Rule 11, with attorney's fees awarded to defendants. I told y'all, a lot of your pro se claims in your chain of assignment, y'all got them from these attorneys, that these cheap sham attorneys that came to this side because they saw money based on the high number of foreclosures that were taking place in the aftermath of the 08 recession. 98% of these pro se social media gurus online, all they did was just follow the same framework for these attorneys 10, 15 years ago, who has all walked back and said none of that works since then. 98% of these social media gurus have gotten their legal defense tricks from the lawyers from the 08 recession stage, the securitization, the remake, by all of it. That's where it came from. So when I say rarely ever are you going to see claims built from scratch, built from frameworks you created from scratch, it is a rarity. Everybody gets something from somebody. We're not talking about the statues in mass. We're talking about the foundations of your claims. This is why the FDCPA, FCRA, this is where this came in the frame pro se spaces, because a lot of lawyers were suing mortgage companies under these same things back then. When there was faulty robo signing, this is when, and they it's not original. It's not taking a statute and making your own claims within that statute while still staying within the bounds of what the statute allows, by presenting your claims in a totally unique manner. The Eighth Circuit affirmed, noting the theory had been repeatedly rejected, that counsel's deliberate failure to address contrary authority suggests an intent to mislead the court, and that such conduct could support further appellate sanctions. A lawyer brought the show me the note theory. These sham counsels. Where do you think pro se litigants today get the show me the note theory from? These 2012, 2013 lawsuits filed by the lawyers and their responses. This is where they get it from. They didn't do their own independent research before they started doing the show me the no theory. They rarely ever do their independent research. It's confirmation bias research. Cautionary citation. Print and keep it in front of anyone who asks for a securitized-based filing. The specific claims to refuse. The securitization voided the obligation or split the note from the security instrument so that no one may enforce. That's what these sham lawyers argue. The borrower holds a beneficial interest or may call securities issued by a trust under the uniform rules for investment property. An entitlement holder's interest runs against its own securities intermediary and generally not against third parties. A borrower is not an entitlement holder at all. Who started that? These sham lawyers did. Any pro se teacher on here that's saying these, they didn't think of it on their own. Because that's all was circulating around these spaces around that time. They just got it and start teaching it from it today. This is why they're always going to continue to cite Phyllis Horace versus LaSalle Bank or the Credit River case. Two cases that's not won anyone in the last 15 years, any foreclosures in their respective states. The teacher could be from Philly. And what are you going to drop a video on? Look, it says it right here, where beneficial interest. An accounting classification on the funder's books. Booking a receivable as a dealer loan, for instance, defeats its assignee's right to enforce a contract. That a consumer who financed or purchased for their own use is an accommodating party rather than the principal obligor. In general court, that won't be sufficient enough. Any argument sourced from a foreign civil code with no application in United States courts. Each of these can be replaced with a narrow documentary argument that survives. An incomplete endorsement chain shown on the face of the instrument, a written assignment, as in Sanders, a charge outside the contract, as in Kmark and Bradley, or a foundational failure, as in Glorm and Shell. The narrow version wins cases. The broader version loses them and draws fees. How the authority maps to the analysis. Finding. Aggregated advance total does not reconcile its part. The legal consequences. Summary is not competent proof of amount. Summary judgment defeated. Principal authority. Glorm, Capital City Developers, Shell. Our findings. Charge assessed that the instrument does not authorize. The legal consequence could be a 1692F and a 1692E. Statutory damages and fee shifting. Principal authority, Kmark and Bradley. Our findings. Fee built, around that. Fee built before the work was performed. Legal consequences. Misrepresentation of the amount of the debt. Principal authority, Kmark. Findings. Entries created on a prior or third-party servicer system. That's what we found out recently when I got the same document that Loan Depot filed, which another loan servicer used. Legal consequences. Foundation failures unless the witness knows that system's procedures. Principal authority. Hunter, Holt, Yang, Glarham, subject to Callaway and Friars. Findings. No written assignment in the record. Claimant fails an element or its own claim. Saunders and Nyanjoko. Servicer answered a specific quantified error notice with boilerplate template. RESPA violation where uncorrected overcharge caused loss. Legal authority, principal authority, Renfro, subject to Brennan and Caldwell. And confirm, check the subsequent history, all that. So that's the legal framework that goes into this. I know a lot of this is going to, but the reality is It's working just fine. It worked perfectly for me in my own case, and it's working just fine in the matter at hand related to the mortgage case that's going on. And they got some things to answer to, because I see a lot of statutory violations. And I'm not so much worried about trying to extract money from a lawsuit. I'm not trying to do that, but especially when it gets to the credit cards, I know a lot of people get sued to go to court, but like I said in the beginning, with credit cards, I don't even go to court. It literally gets settled administratively. Like it literally does, because with the credit cards, especially just, hey man, your accountant's wrong, the imbalance, inaccurate due, this is what it is here. And they typically, the typical response has been, we have ceased collections. You have no more collections under this account, or no more obligations under this account. So the Set You framework worked brilliant here. It worked brilliant here against Westlake. And it is working brilliant right now in a mortgage case. And we anticipate it continue to work brilliant when we strengthen up the foundation, continue to build upon it, continue to stay steadfast, continue to take it one day at a time, and continue to stay within the confines of what the law allows. And we let the chips fall where they land. What you don't want to find yourself. All right, authenticate your birth certificate. Now you got, you want to learn the process? Me $250. All right, here. That ain't work. What you do now? Oh, no, you ain't get the embosser. Oh, that's another. I give you $500. All right, I ain't get this money. What's next? Went there, took it to they rejected. Nah. You missed the bond paper. Give me $100. I'm gonna send you the special bond paper. Oh, okay. Hey, nothing still happened. No. See, we gotta dye the bond paper. It's a special dye that you gotta put on the bond paper. Oh, how much is the bond? Oh, that's only $175. It's a special dye because when they touch it, like it gotta process through the scanner in the system in a special way, the secret way. Okay, here's $175. Nothing happened. No, because you were supposed to put it on the tax form. You never said. I did. I said, remember, once you get all that stuff, you might have to come back to me for the taxes. You don't remember? I sent you the text. I didn't get no text. Oh, look, I've been dealing with so many people. Hold on, let me go ahead and type it up right quick. And then making sure like I didn't send it. I'm just gonna leave it in the box, but I'm not gonna send it. Hold on. See, it's right here. Oh, see, look. It never sent. I forgot to send it. Oh, well, how much is for the tax? $600. I'll do the tax for you. All right. Boom. Get it? Bam. IRS response. Courts have considered claims like yours to be frivolous. Look, we don't have to go far. Look.
Everybody that's trying to monetize their birth certificate bond, first you're going to need your CUSIP number. So let's look at the CUSIP number and find out how much the bond is worth.
What is that birth certificate bond? What is she doing? Going on the ancient old fidelity crap. What year is this? What do you know? 2023. They talk about, it looks like Fidelity has found out people are aware of their birth certificates are worth money and block it. They don't understand how securities work. In order for security to have value, it has to be backed by a financial asset that is producing cash flow. As of the October 25th, 2015 statement, the plaintiff is allegedly to pay out $108.32 in interest and fees. The defendant creates money out of thin air and burdens the plaintiff through a debt slave. What did I tell you? The vapor money theory. Yeah. The vapor money theory. Oh, you ain't loan me nothing. You create out of thin air. You ain't really gave me nothing. don't got paid back now. Well, when did you find this out? When I was $5,724 in debt. Well, why didn't you figure it out from day one after you read the contract? Oh, because I ain't give it. Before I filed my lawsuit, when I found out all the violations with them, you notice that it wasn't until I was ready to file the lawsuit that I even said, forget that, I'm not paying you. I even offered them $10,000 for the vehicle based on the violations. Like, if they would have agreed to that amount, there would have never been a lawsuit. Hey, here's some violations on you. Look, I know I'm able to prove this in court. So let me just give you $10,000 for the vehicle. Now, many people will be like, nah, don't give them nothing. But me, I believe in equity. I believe in equity going both ways. I believe in getting equity and I believe in giving equity. I try to do the right thing when I can do it all the time. I always first, the corporate finance, you be in compliance the whole way. You do the right thing on your end, because when it gets in court, they can never say, well, you never paid back. You're delinquent. I can at least bring my arguments and say,
Credit acceptance, you tryna finesse interest payments. No, I couldn't let them get me caught in front of the house inside Mercedes Benz GLE, but something wasn't right. I had to do it right. Yeah. Sent the email with the proof, then I filed a suit. Yeah, judge saw the evidence, then they called the truth. Sleep just like that, gone. They settled quick, title on the way, and the debt was wiped away, and I ain't even had to pay. No, push the.
Join the Patreon, the New Culture Empire at the Patreon. You can join the Patreon if you are interested in being in that credit repair class that with my good friend taught. You could sit there and you get all the information you need, and you can start putting your own claims together from there. Interested in an audit? Want me to audit your account? Well, we're going to audit. I work with a team, by the way. You already know what you need to provide. You already know what it's going to produce. You can sue them under you can RESPA, whatever consumer claims you want to sue them under. You can sue them, fair credit reporting. You can sue them, or you can use that to challenge the amounts due, the balance asserted, deficiency, the credit card balance. It arms you with direct evidence and from the record that they built. Now, with that being said, all inquiries should be sent to thomaslegacy603@gmail.com. Just need a case review or whatever tickles your fancy. If it's something we can do, we'll do it. If it's something that we can't, I will let you know or point you in the right direction. People been reaching out saying, hey, do you think you get the attorney to do it? Let me tell you this. I've asked a couple times. Let's just say, unless you got at least 50,000 in the cut, he's not even going to entertain me, or even though he's not a very busy man. Then he's got to look at the case, got to make the determination. But like, he's not even going to even hear unless I'm saying, yo, they got 50,000. Like, yeah. He is not even going to. People asked me before, and I try to tell them in a roundabout way, you can barely afford me. You don't have to pay that man that laying around right now. And those lawyers, they're billables. They charge you by the hour. They don't charge you by the hour. You're going to pay a high-ass retaining fee, then you're going to get built by the hour. And if you're in a mortgage, auto, complex securitization, you may be paying upwards of $100,000 to that man. I'm just being honest with you. That man is not cheap. That man is super expensive, super duper expensive. I mean, he comes from the Morgan and Morgan family. He is not cheap, and it got to be a compelling reason why he would even step in and take the case. It's just not happening. I'm sorry, it's just not happening.
So I know a lot of people ask me if I could ask them. I've done it. I've done it twice. I'm not asking anymore because I already know what the answer is. He's not doing it. So with that being said, I want to thank everybody for pulling up. I want to sit back for the rest of the day. You know, relax, probably get a couple hours in on my research mode and start preparing, getting the groundwork down for the audits and start, excited to see what it produce, what someone can use in their case for. See what it produce. All right, y'all.
Run it up, running band. They scared of my team, they know who I am. They rolling the dice, we won cause we plan. The things that they teach don't know how to stand. On my wrist like a stage, they can't glance. You look like you wanna let go of stress. What's up? I thought so. Oh, I am the blueprint, if not, why you copy me, fam? What's up? I thought so. Okay, I cannot help that they copy. Hey, I am their dad, call me Poppy. Yo, they wish they created the set. Yes, they on my D like a jockey. When it comes to the print, I'm the blue. Who? Every complaint, draft is smooth. Supreme Elite team be the ones. Yo, I created my own school. Facts. I came from the trenches. I came from riding them benches. To proving my case with exhibits. My craft is exquisite. I find where they hiding them digits. The cancer is not in remission. Hey, please pay attention. You can't recreate the five lenses. You can't duplicate what is written. You either gonna pay the tuition or pay for assistances. Or pay the mistakes when you case it, dismiss them. I come with everything that's under the kitchen sink. I haven't slept in a week. They scared while I'm willing to compete. These scammers are devils and I keep them under my feet. Ay, they saying they win, I never take their prescription. They never coming from the plaintiff's position. I am the blueprint, blatant admission. Check it, when I talk classes in session, professionals, even the tacos respect it. Show me a win, that's not a rejection. Tell me the truth without all the stretching. These gurus are boring and it's stretching. These students are dumb, desperate depression. Set you, yeah, I'm done with this lesson. Came from the streets, still I'm a step up. Run it up, running band. They scared of my team, they know who I am. They rolling the dice, we win cause we plan. On the things that they teach, don't know how to stand. On my wrist like a stage, they can't glance. You look like you wanna let go of stress. What's up? I thought so. Oh, I am the blueprint, if not, why you copy me, fam? What's up? I thought so. Okay. New culture, he running this shit. Hey, like he came with a gun in this bitch. Black, and he double up wins back to back. Oh, like he ain't even done with this shit. Now come to court like a dog off the leash. Dismantle the evidence, break down their claims, and he start from the top of the sheet right here. Whenever he taught, they retreat. He's a lead with his team, they supreme. He brings reality out of drink. Okay, they can't help but watch from the clouds. They trying his awards and the memes. Alibi with the feds. You fuck with alibi, you be in the feds. Lawful levy, still a rookie. Can't stand on the shit that they saying. Hey, he beat his case, he beat CAC to submission, stipulated the disposition. Westlake, he tried to give a break. Attention they didn't want to pay. Made them max sit, they on case. Get the fuck out his face. The new culture ain't want to play. The new culture running this shit. The new culture with debate. Anyone who think they running this shit, he take your docs and expose that shit. Gon' be acting like you never sold that shit. They copy his drip like he sold that shit. Ain't no guessing with him, gotta know that shit. Hey, you gotta know that shit. He be credit acceptance, I be Westlake. Whatever I'm serving, they eat the plate. They don't watch me loud, but they watch from the clouds. They copy my style, but can't figure me out. The 5 messages I created that you can't duplicate from an AI chat. He thinking things that they can't comprehend and teach what people did not know exist. Run it up, running band. They scared of my team, they know who I am. They rolling the dice, we win cause we plan. The things that they teach don't know how to stand. On my wrist like a stage, they can't glance. You look like you wanna let go of stress. I thought so. Okay, I'm the blueprint, if not, why you copy me, fam? I thought so. Okay. I thought so. Okay. I thought so. Okay.
You're rocking with the best. You're rocking with the best. You're rocking with the best.